Good afternoon and welcome to the Appellate Division, First Department. I will begin with the call of the calendar. Counsel, please listen for your case. People versus Jose Remigio. Appellant.
Good afternoon, Your Honor. Stephen Strother from the Office of the Appellate Defender on behalf of Jose Remigio. I believe I've been given 4 and 2.
That's correct. Welcome. Ms. Bond for the respondent.
Yes, hello, Rachel Bond for the people.
And you have been granted 4 minutes.
Yes.
American Transit versus Health Plus. Mr. Short for appellant.
Hello, Your Honor.
Hello. And you've been granted 4 and 1. Respondent, City Med Services, Mr. Kim.
Yes, Your Honor.
Good afternoon. You've been granted 4 minutes.
Thank you.
Case ACS case, Angelica, appellant.
Appellant, do the stern appearing on behalf of Angelica A.
Yes, you've been granted 4 and 1. Good afternoon.
Good afternoon.
Respondent.
Good afternoon, Your Honor.
Good afternoon.
For the respondent.
Sorry about that. There's always a delay. How are you, Mr. Zipkin? You've been granted 3 minutes.
Thank you very much.
Martinez versus St. Dill is submitted. Neighbors United versus de Blasio. Ms. McCamphill.
Good afternoon, Your Honor. Ms. McCamphill on behalf of the appellants.
Good afternoon. You've been granted 8 and 2.
Thank you.
And Ms. Mouch.
Good afternoon, Your Honor. Helen Mauch, Minster Mauch for respondents.
Good afternoon. You've been granted 8.
Thank you.
And this case will be called out of turn as we have a vouching judge. Judge Gonzalez will be stepping in for Judge Mazzarelli, who was recused on the case. The matter of Biggin versus you're welcome. Biggin versus City of New York, Ms. Duffy.
Good afternoon, Your Honor.
Good afternoon. You've been granted 4 and 1.
Thank you, Your Honor.
Good afternoon. Ms. Fillo.
Yes, good afternoon.
Good afternoon. You've been granted 4 minutes.
Thank you.
People versus Saul Olavaria. Mr. Palmer.
Yes, John Palmer for Saul Olavaria.
Good afternoon, Mr. Palmer. You've been granted 3 and 1. Mr. White.
Yes, Your Honor.
Good afternoon. You've been granted 3 minutes, sir.
Thank you, Your Honor.
Mironov versus Memorial Hospital. Appellant, Source NJ, Mr. Schultz.
Good afternoon, Judge Manzanet.
Good afternoon. You've been granted 4 and 1.
Thank you.
Respondent, Memorial Hospital, Mr. Simone.
Good afternoon, Judge.
Good afternoon. You've been granted 3. And Respondent Mironov, Mr. Serpico.
Good afternoon, Your Honor.
Good afternoon. You've been granted 3.
Thank you.
And I believe Mr. Serpico will argue first, Judge, if that's okay. For the respondent.
As for the respondents, that's fine.
Okay, thank you.
Okay. Chung versus 48 Tenants Corp., Mr. Sobel. Mr. Sobel.
Yes, Your Honor. My apologies. I was still muted. Curtis Sobel from Sobel Pevsner for the appellant, and good afternoon to you.
Good afternoon to you. You've been granted 6 and 2. Respondent, Ms. Camo. Did I pronounce that correctly?
Yes, Lisa Camo. Good afternoon, Your Honor.
Good afternoon, and you've been granted 6 minutes.
Thank you.
Conrad versus City of New York, Mr.
Karen Dipple for the appellant.
Good afternoon. And my apologies, I thought I saw a Keith rather than a Karen. My apologies. 6 and 2. Zachary Shapiro.
Yes, good afternoon, Your Honor.
Good afternoon, and you've been granted 6 minutes.
Thank you.
Otto versus Otto. Respondent, Mr. Lynn Jr.
Yes, Your Honor.
Good afternoon. You've been granted 5 and 1. Ms. Besunder.
Yes, Your Honor. Good afternoon.
Good afternoon. You've been granted 5.
Thank you, Your Honor.
U.S. Life Insurance versus Horowitz, Mr. Schessler.
Yes, good afternoon, Your Honor. Kevin Schlosser for the appellant.
I'll do better the next time. Thank you. You've been granted 5 and 2. My apologies. And Mr. Lux.
Yes, good afternoon, Your Honor.
Good afternoon. You've been granted 5 and 2.
Thank you.
Thomas versus Triborough Maintenance is submitted. Mickle versus New York City Department of Education. Mr. Carlin?
Yes, good afternoon, Your Honor.
Good afternoon. You've been granted 3 and 1.
Thank you.
Ms. Paulson?
Yes, good afternoon, Your Honor, on behalf of New York City Department of Education.
Good afternoon. You've been granted 3 minutes.
Thank you very much.
You're welcome. Ad Plumbing versus Burlington Insurance. Appellant, Mr. Delahunt?
Yes, good afternoon, Your Honor.
Good afternoon. You've been granted 5 and 1. Mr. Adrian?
Good afternoon, Your Honor. Bergen, I'll be arguing for Burlington today.
Okay, and you've been granted 5 minutes. Star Russia versus Deloitte Touche is submitted, and Breakaway Courier Corp versus Berkshire Hathaway. Appellant Breakaway, Mr. Karsich?
Yes, Your Honor.
Good afternoon. You've been granted 5 minutes. And appellant Current Lighting, Mr. Dowd?
Yes, Your Honor.
You've been granted 5 minutes. And respondent, Mr. Noser?
Your Honor, may we have 4 and 1?
As a respondent, no. You have 5 minutes.
As a plaintiff appellant.
Your Honor, this is Michael Noser for Berkshire Hathaway.
Right.
And I recognize I have 5 minutes. I think it was Mr. Dowd on behalf of Current Lighting who was asking the question.
Okay. That's why I said no, because I thought I was talking to Mr. Noser. So yes, Mr. Dowd, you may have 4 and 1 as you are an appellant.
Thank you very much, Your Honor.
You are welcome. Okay. The first case on the calendar, Neighbors United versus Mayor Bill de Blasio. Judge Mazzarelli will step off of this case and Judge Gonzalez will step in.
Thank you. I'm here.
Okay. Let me get you on my. Okay. There you go. All right. Ms. McCampbell, you have the floor. You have 8 minutes.
Good afternoon, Your Honors, and may it please the court. Amy McCampbell on behalf of Mayor de Blasio and the other appellants. Your Honors, the lower court's order here, which puts a halt to the planned construction of the city's Manhattan Borough-based jail, it entirely misapplies governing law under the State Environmental Quality Review Act, SECRA. And what's more, the lower court also misread the record in many respects, as petitioners themselves concede. Now, the lower court's holding was based on 5 grounds, and on appeal, petitioners defend 4 of them, pertaining to scoping, alternatives, potential public health impacts from demolition and construction, and traffic analysis. And none of these 4 grounds provides any basis to overturn the environmental and land use reviews here. These reviews were thorough, they were responsive to public feedback, and they complied with all applicable laws. Unfortunately, the lower court's order puts a halt to construction of this critically important public project and upends well-settled.
This is Judge Gonzalez. Would you please address the issue of scoping relative to 125 White Street? I understand that it's your position that significant post-scoping changes are allowed to a project. However, the community was initially noticed with respect to 2 locations, am I right? 125 Worth and 80 Center. The emphasis then shifted to 80 Center. All the input was asked to 80 Center, and then there was a change because of community opposition to 80 Center. Now, a lot of people would say 125 White was most likely the preferred location from the beginning because there's a building there already and it's used for detention purposes. So was this bait and switch on your part, or was there a true opportunity afforded to the community to participate as to White Street, not 80 Center.
Your Honor, there was certainly no bait and switch on the part of the city, because the change was made largely in response to public feedback that the city had received. And 2 points, Your Honors, with respect to scoping. First, as Your Honor mentioned, the regulations explicitly contemplate that projects may change after scoping is completed, and neither the state nor the local rules require agencies to go back and restart scoping in such circumstance. So therefore, it was entirely reasonable for the city not to go back to square one and restart scoping when a change occurred during the scoping process. And moreover, even if it could be believed that some change during a project could be so dramatic as to warrant a repeat of the entire scoping process, the city's determination that that's not what happened here was entirely reasonable and should be upheld under Seeker's rule of reason. Here, after the project change reverted to the White Street site, which had previously been announced as the planned project site for the Manhattan jail, it still contemplated a jail of the same size with the same features in the same immediate vicinity. And the draft and final scope in the record show that the environmental considerations did not significantly change between the draft and final scope as a result of this reversion in siting. And a final reason, Your Honors, why the lower court's order on this point was so off base is the fact that petitioners have not made any argument as to how the substantive environmental review could possibly be improved by repeating scoping at this point. The entire purpose of scoping.
Well, the Manhattan Borough president asked repeatedly that there be additional time afforded so that the Chinatown community in particular could comment because it's the neighborhood adjoining the building as it currently exists.
Sure, Your Honor. So again, the immediate vicinity of the project is still the same because the project moved from one side of the courthouse to the other. The Manhattan Borough president did request additional scoping after the project had changed, and the city in multiple letters explained why it had determined that a repeat of scoping was not warranted here. And again, because the same environmental considerations came into play, because there were additional opportunities for public feedback during the substantive environmental review process and during the Euler process. For all of these reasons, the city reasonably determined that repeating scoping would have no benefit here. And again, petitioners have never connected any of what they allege are the deficiencies in the substantive environmental review to their claim that scoping needed to be repeated. And for those reasons,
let me ask you a question, a different question. So one of the concerns raised in the decision below and by the community is that alternatives were not really considered. And one alternative set forth in the your adversary's brief was the possibility of using the existing building and renovating it, particularly in light of the fact that the number of beds initially contemplated at more or less 1,500 was now reduced to 880, which I believe is but what 13 or 18 more than what the current facility actually has. So my question to you is, wasn't this a reasonable alternative that could have been considered once the focus of the city was on 125 White?
Sure, Your Honor. So the EIS did explain in detail why certain alternatives, such as adaptive reuse, were rejected as unfeasible for this project. It was explained in the EIS. And the key reason for adaptive reuse being unfeasible here was that the project contemplated a facility that is much larger than the existing facility. In the EIS, the project that was contemplated was about 3 times the size of the gross square footage of the existing facility. Now, as Your Honor mentioned, the project has subsequently decreased in size, but the most recent tech memo that discusses the project size from October 2019, the project discussed there is still about twice the size in terms of gross square feet as the existing jail.
And this makes sense. About, Council, vertical size or horizontal? You're talking about square footage.
Square footage.
With as opposed to height?
The overall square footage of the project, as contemplated with the reductions during the public review process, is still about twice the size of what the current facility on the site has. And but this makes sense.
Those numbers were aimed at a population of 1,500 people, which is not.
No, Your Honor. Even after the jail size population decreased, the facility that's contemplated here is still much larger than the existing jail. And the reason for that is because the point of this project is to improve the jails. We're going to create more humane, modern, borough-based facilities that are going to have amenities the current jails simply don't have. There's going to be increased programming space, there'll be outdoor access, there'll be increased space for meetings with service providers and family members, there'll be more natural lighting, and none of that is possible in the existing jail building. And that's why the facility contemplated by this project requires a new building on the site. Adaptive reuse is not feasible. And again, the discrepancy in size is explicitly discussed in the EIS, which explains why it was not feasible to do that for this project for that reason. And because the EIS explains in detail why other alternatives, such as alternative sites and alternative jail plans, such as adaptive reuse, were rejected as infeasible, the EIS shows why the city's consideration of alternatives was reasonable here in light of the objectives of this project. And that's how reasonableness is considered for the alternatives analysis under the SECR regulations.
A different question, prior agency approval of the project, agency approval prior to the finalization of the SECR process. Is that something normal or is that aberrational?
I believe Your Honor might be referring to the point that petitioners raised in their brief about the Department of Corrections transferring detainees. So the transfer of detainees and budgeting activities and project planning, those are routine agency actions, and they're exempted from SECR under the SECR regulations. Preliminary budgetary and planning processes and routine agency actions do not trigger SECR review. Moreover, this was a point that petitioners hadn't raised below, and again, they simply raised for the first time on appeal, but it has no merit in any event. I'd like to move on to the.
You'll cover that on appeal, okay, on rebuttal, all right?
Thank you, Your Honor.
And if you need extra time, I will give you. All right. Ms. Mowich.
Thank you. May it please the court. Helen Mauch, Mincer Mauch, for the respondents. In our brief, we set forth a number of reasons why the lower court correctly annulled the approvals for the Manhattan jail. I'd like to begin my argument discussing the issue raised by Justice Gonzalez regarding scoping. Scoping is a mandatory procedural requirement under City Environmental Quality Review. The Court of Appeals and this court has said over and over again that the substance of SECR cannot be accomplished without its procedure. Departures from SECR's procedure frustrate the very purpose of the statute. And for that reason, there is a stricter standard that applies to procedural violations, which is what we have here. That standard is literal compliance. Substantial compliance is not enough. And the rule of reason that the city relies upon does not apply. SECR's procedure is non-negotiable. There are two distinct opportunities for public comment under SECR. Both are mandatory. One is not lesser or greater than the other. The first opportunity for public comment comes before the draft environmental impact statement is issued. It's known as scoping. It gives the public and the interested and involved agencies an opportunity to weigh in on the contents and the scope of what should be in the DEIS. The second opportunity is after the DEIS is issued, there is a public comment on that document. In this case, the city completely cut out the first step of public involvement and violated.
Council, the organization that you represent would be the same group of community people who would have participated in the scoping process that did occur in any event, regardless of which site was named. This organization would have been involved as part of the community in looking at the project and making sure that the city followed the guidelines and the statutory requirements within the city and state, right?
we represent one organization. We also represent individuals. And our clients do not include every member of the public.
Of course not. No organization would. That's not my point. My point is that your people were at the table. The organization you represent was part of this process with regard to the scoping that did occur with regard to the 80 Center Street location, right?
They were at the table for a different project. They were at the table for the project that was scoped at 80 Center Street.
Precisely. And so they were aware throughout that process that there was great community pushback about using the 80 Center Street location, so that in light of the fact that the 125 White Street location had been noticed in early documents by the city, you were aware that 125 White Street, in light of the discussion going on during the scoping and the pushback about 80 Center, that 125 would then be the logical next location to look at, if not 80 Center.
No, we don't concede that at all, Your Honor. And as a matter of fact, if you look at the record, what you're referring to is the city's contention that they merely reverted back to the site at 125 White Street. The record in this case, the only thing in the record relates to the possible repurposing of a jail at 125 White Street. The proposed action in the DEIS is for a jail at 124 and 125 White Street, demolition of those two massive buildings, demapping of White Street, loss of an open pedestrian plaza that was promised to this Chinatown community when the jail was originally constructed, and a 19-month demolition period and a 3-year construction period of a massive new jail on both 124 and 125 White Street. So the reversion argument we submit is completely bogus.
Okay, well, I didn't classify it as a reversion argument, but you can continue.
Thank you. I would like to address the comments made during my adversary's opening argument. The immediate vicinity of the project did not change. That's what counsel said. But the record in this case indicates that the city itself identified substantial differences between the vicinity of 80 Center Street and 124, 125 White Street. One is a civic core, the other is a residential community. And there was reference to there being no benefit to re-scoping. We are not talking about re-scoping. We are talking about undertaking the public comment requirement for the proposed action that is in the DEIS, and that did not occur here. There's no re-scoping. A jail for 124, 125 White Street was never scoped. And the issue raised of petitioners not showing.
So, counsel, there were a number of meetings that were held. There was a public scoping meeting in September of 2018 with respect to the draft scope of work, right? And you have a public hearing by Community Board 1, a ULURP hearing. You have meetings, subsequent meetings by CB1 and CB3, and then you have extensive recommendations by the borough president and an approval. How does that play into your argument that there was no information and there was no discussion, there was no scoping as to 125 White?
There were, I want to be clear here, there were a total of 2 public comment opportunities here. One was on July 10th, and that was the combined DEIS and ULURP public hearing, and one was on September 5th. That was the City Council Land Use Committee meeting.
Right.
The city did not go above and beyond by convening an invitation-only neighborhood advisory council meetings. They didn't even meet the bare minimum because SECRA requires that there be a public scoping meeting on the proposed action that is the subject of the DEIS, and that did not occur here. So the refrain that there was ample comment is another way of arguing that the strict compliance standard does not apply, and the case law is clear that when it comes to procedural violations, as there is here, it is strict compliance. A procedural violation cannot be cured, this court has said, and the Court of Appeals has said, by a legislative process or meetings outside of the public purview.
So what, I mean,
Go ahead if you have another question.
please. So what you're saying is that at both the July 10th and the September 5th, 2019 meetings, there was no discussion as to 125 White?
Those were the only two public meetings.
No. I hear you. My question is, at those two meetings, was there discussion as to 125 White?
There was discussion as to 124, 125 White Street. But again, there is no cure for a procedural violation. So the fact that there was public comment on the DEIS, the second public comment requirement, right, on the DEIS does not cure the failure to provide the public with the opportunity to weigh in on the scope and the contents of the DEIS.
And if I may, you're referring to the ULURP process?
No, I'm referring to the city environmental quality review process.
Okay.
Thank you so much. You have 2 minutes, Ms. McCampbell.
Thank you, Your Honors. The petitioner's argument that this is a procedural violation is entirely incorrect. Petitioners have never pointed to anything in the regulations that require scoping to ever be repeated. And in fact, the regulations explicitly say that even if you have to do a supplemental environmental impact statement, you repeat every part of the review process for that except for scoping. So it's very clear that the regulations do not contemplate this kind of repeat scoping that petitioners are arguing is a procedural violation here. It's simply incorrect. And then we fall back to the secret rule of reason again. And here, the city's determination not to repeat scoping was entirely reasonable for the reasons already discussed. Now, petitioners claim that they were surprised when the White Street site, where the current jail is located, was ultimately chosen as the jail site. But we cited a press release in our papers in which the city announced the White Street site. Now, it's true that all the details of the plan weren't announced in the press release, but certainly the fact that this site was under consideration was very clear to the community from day one. And petitioners argue that scoping was never done for the White Street site. The final scope of work addresses the White Street site, and petitioners have never alleged how they think that final scope of work is deficient in any way. So for all these reasons, you know, their scoping claim simply has no basis under the regulations, no precedent under case law, and it's simply illogical. And for all these, thank you, Your Honor.
Thank you. All right. Thank you, Judge Gonzalez. And we'll wait for Judge Mazzarelli to rejoin us.
Thank you.
Thank you. And if counsel, Mr. Struther, if you could be, there goes Judge Mazzarelli. Mr. Struther, you may proceed.
Good afternoon, Your Honor. Stephen Strother from the Office of the Appellate Defender on behalf of Jose Remigio. Your Honors, Mr. Remigio's case must be held in abeyance and remanded for a prejudice hearing because his counsel provided on the record improper advice as to the consequences of Mr. Remigio's conviction for robbery in the second degree. In a trio of cases, People v. Johnson, People v. Picaro, and People v. Rodriguez, this court's made clear that the kind of advice given here, in which counsel said that Mr. Remigio may very well be deported, and that's what he's told him, that is...
Excuse me, this is Judge Mazzarelli, but is there anything to the people's argument that all of this is tilting at windmills because your client has already been convicted and sentenced on another crime, which would be a mandatory deportation crime?
No, for two reasons. The Pettit larceny conviction is not an aggravated felony. For one thing, because New York recently changed the law to automatically reduce misdemeanor sentences to 364 days, that Pettit larceny conviction does not have 1 year in prison, and therefore it's not an aggravated felony because aggravated felony theft offenses require 1 year in prison. Secondly, the Second Circuit recently issued an unpublished opinion, Smith versus Barr, 809 Federal Appendix 54, stating that New York larceny is not categorically an aggravated felony because it contains a fraud element that is not present in federal larceny. So we believe that there's no chance that this larceny conviction would result in Mr. Remigio's automatic removal from the United States. This robbery conviction is the conviction that makes him mandatorily deportable. The key here is the Johnson case at 165 83rd 556. The language or the advice given by counsel in that case is linguistically identical to the advice given in this case. It's on the record that he advised his client that he probably may very well get deported. Here it's he may very well get deported. In that case, this court remanded for a prejudice hearing. There is no way to factually distinguish Johnson in this instance from this case. Now, I'm aware that my adversary cites a couple of recent cases from this court, Gomez and LaFontant, but in neither of those cases did counsel say, I have advised my client that they might be deported in the way that we're talking about with Johnson and in this case. In Gomez, all that counsel said was, I told them about the possibilities, his immigration possibilities. Under those circumstances, there's no content to that advice, so of course we need a 440. Here, there was content. He said, I told him he may very well be deported. That is what triggers the remand. It's because it's not advice that immigration deportation is going to follow sort of absolutely from this conviction. In LaFontant, the attorney provided no advice at all on the record. So of course a 440 was required. All he did was answer the judge's question as to, did you advise your client about immigration consequences? And he said, yes. There is no content to that statement. So we don't think those cases really affect the outcome here. What matters is Johnson and Rodriguez and Picaro, where this court's holdings are really on point as to the facts of this case.
Thank you. We'll hear you on rebuttal.
Thank you, Your Honor.
Okay, Ms. Bond.
Good afternoon. May it please the court. Rachel Bond for the people. Here, I'd like to respond to counsel's argument that here is factually indistinguishable from Johnson in that line of cases because the counsel said, I have advised my client that he may very well be deported. The conversation here, we're not sure what the conversation was.
But counsel says that he used that same language. He may very well be deported, and that is absolutely insufficient.
So what the defense attorney actually said was the conversation I had with Mr. Remigio, and which I think he understands, is that his plea in this case may very well result in him being deported, and then he gets cut short in giving his summary. So he doesn't say that that's all he said.
That means even more so. That doesn't help you. That means even more so we need a hearing. Because what I do have on the record is may very well result, when you and I both know it's not may very well results, it's a mandatory result. And so anything shy of this is a mandatory result is questionable advice.
Yes, Your Honor. However, the record here is very vague because counsel, it appears, was going to continue his summary of the conversation based on the transcript. He wasn't able to finish that summary. The word conversation can indicate that more was said to the defendant than what was put on the record here. And all of that ambiguity just highlights the need for a 440-10 motion here, rather than ruling that it was misadvice on the record at this stage and then remanding, holding it in abeyance and remanding for a prejudice hearing. It's all very ambiguous as to what this conversation was. Defense counsel was not asked to volunteer any sort of specifics to clarify what he meant by may very well be deported. And quite frankly, that's just too vague for anyone to conclude that it was affirmative misadvice, that he was definitely telling him, oh, it's just potential that you'll be deported. It's not.
Aren't attorneys held to a standard of practice? I mean, an attorney knows what needs to be put on the record, and attorneys get cut off by judges all the time. Today being an illustrative way of illustrating that point, right? So it's the obligation of counsel to make sure that the record is complete. What I have on the record is clearly a violation. I think Judge Mazzarelli has something she would like to chime in.
I was just going to add to that. I think you already alluded to it, that the vagueness itself, you're arguing it's vague, that itself enhances the position of the appellant, that we need to clear up this vagueness. We need to have a hearing.
Well, I would agree that there needs to be a hearing. I just think it needs to be a hearing on a 440-10 motion, because I think that that's what that's for, to expand the record, to find out what it is that counsel said to the defendant in this off-the-record conversation.
Are you suggesting that on this record, it would be improper for us to do that now instead of wasting everybody's time waiting for a motion that will only be granted and result in the very same hearing we're considering now, in light of our very scarce judicial resources?
I'm not suggesting that we waste judicial resources. What I am suggesting is that there needs to be an expanded record as to what was said in this conversation. And I think that that is most properly brought via a 440-10 motion. Claims and ineffective assistance of counsel claims generally need to have, on the face of the record, if it's going without a 440-10, it needs to have a showing of both prejudice and of the violation by counsel. And I don't think that either of those are apparent on the face of this record.
Thank you. Mr. Strother, you have 2 minutes.
I just want to make 2 quick points. So the point about the attorney getting cut off is just a red herring. I mean, what will we be having a 440 for? So that he could say to the judge, actually, I was also going to place this on the record. That's not really the kind of thing you normally have a 440 to talk about, is what counsel would have said on the record. And even if we had a 440 and counsel said, yes, I told him he may very well be deported, but then I also told him that he was going to be deported for sure, that confusion to the client by itself would likely be an IAC violation, would be ineffective assistance of counsel, because he still would have told his client that his deportation wasn't guaranteed, or he would have given him mixed messages. The point here is that there really is, the case law is pretty clear. When counsel states on the record, I advised my client in an incorrect way, then the case has to be remanded for a prejudice hearing. Especially in a case like this. This is not complicated. We're 13 years after Padilla. Immigration lawyers are supposed to know that violent robbery felonies are mandatorily deportable. It is a really basic concept, not difficult to give the correct advice. And so we just don't think there's any basis for departing from this court's precedent. If there's no further questions, thank you, Ron.
Thank you. Okay. ACS versus A. Angelica. Ms. Stern, you have 4 minutes. Ms. Stern, if you're trying to speak, you must be on mute.
Mute. Now I'm off of mute.
Okay, great.
Thank you. Good afternoon, Your Honors. Truth Stern on behalf of Angelica A. Your Honors, in this case, the family court, after finding that Angelica had been repeatedly sexually abused by her father, denied her a dispositional hearing, and in so doing, denied her the opportunity to seek services and the court's protection from her abuser, and only because by the time of disposition, due to repeated delays in family court, she was 18 years old. The court believed it had lost jurisdiction over her because of her age, but in fact, Article 10 of the Family Court Act places no such age restriction on the family court's jurisdiction. Rather, while an abuse or neglect petition must be filed before the child's 18th birthday, once that requisite is met, the court retains jurisdiction until the completion of the case.
But under the family court law, as I understand it, and please correct me if I'm wrong, once a child is past the age of 18, a court can only issue an order of services if the child is still under the jurisdiction of the court. So either she is under some kind of guardianship order or is in a foster care setting, then the court continues to have jurisdiction until the child is 21, as I understand it. Is there another section that would alleviate those restrictions?
So, Your Honor, those provisions that you're speaking of, at least the ones that are referred to usually as 1087 and 1089, those are Article 10A of the Family Court Act, and Article 10, and they regard to this with regard to permanency and permanency provisions and permanency hearings, and that does involve children placed in foster care. But this is not that issue. This is an issue under Article 10, and it deals with the court's jurisdiction. And what an Article 10 says, and it says it in 1013C, is that in determining jurisdiction, under this article, the age of the child at the time the proceedings are initiated is what's controlling. So as long as the Article 10 petition is filed...
Tell me under what provision past the child's emancipation. I agree with you that the court had jurisdiction here at the time that the petition was filed under the section you've just cited. I agree. My problem, okay, and I don't think anyone would argue with you that a child who has endured what this child has endured should, if at all possible, get the services she's requesting. We are all sympathetic to that. What I need to know is, how do I do that legally, and how could this judge have done that legally in light of the family court sections that say once they're emancipated, even if started on time and before her emancipation, that for the court to order, there has to be some kind of either foster care placement or a guardianship with a kin that would substitute for that. And we don't have that here.
But Your Honor,
am I wrong about that?
Your Honor, if you look at Article 10 and you look at the case law that says that a child can be, there's certainly no dispute. Respondent doesn't dispute it, the case law doesn't dispute it, that a child who, once the petition is filed, and the controlling factor is the petition is filed before the child's 18th birthday, that there can be a fact finding. You go to fact finding. There can be a finding of abuse or neglect after the child is 18. It makes no sense to say there can be a finding because we found that this is a vulnerable child, she's over 18, but then there can be no disposition. And because the purpose of the disposition is to provide services and support and protection for the child that has been found to be a vulnerable child. It makes so, and jurisdiction under Article 10 commences with the filing of the petition, and as long as the child is under 18 years old, then jurisdiction continues until the completion of the case. You can't just leave a finding with no disposition, just leaving a child unprotected. The statute contemplates extending jurisdiction beyond the 18th birthday.
Have you cited any specific case law that is close to this fact pattern that I can look to? Because I clearly didn't read anything that's told me that. So if you have something.
The case that speaks to some degree about this, I mean, honestly, this issue has not arisen before, but the case that does speak about this to some extent is matter of Julissa P. It's a lowercase case. And it's cited in both of our briefs. 52, MISC 3rd, 382. And it is that's the case where the family court says, specifically says, the child is over 18, there can be a dispositional hearing. We may be limited in what the court can do at disposition, but that is not a jurisdictional matter. That is a dispositional matter. So that the jurisdiction continues, but it may, and I concededly, because the child is older, there's a number of the kinds of dispositional orders that can be issued, the extent of protections that could be granted may be limited. But so long as a child is seeking the family court's protection, so long as it and the court deems they require that and will consent to the court's oversight, then the family court is obligated to provide at least to hold a dispositional hearing. I mean, if you look at the dispositional provisions, which is set forth in 1052 of the Family Court Act, it sets forth dispositional requirements. And interestingly enough, one of those dispositional alternatives is placement in foster care. So even if
didn't that have to happen before she turned 18?
No, no, Your Honor, it does not have to happen before she turns 18 if she consents to go into care. It could happen at the time of disposition. And disposition is when it has to happen under an Article 10 case. So as long,
all right, you have time on rebuttal, okay?
Thank you, Your Honor.
Mr. Zipkin, I'll hear from you.
Good afternoon, Your Honor. May it please the court, Saul Zipkin, Bronx defender, for the respondent mother, Amalia R. The answer to Judge Menton, I think the answer to the question you asked earlier is that the court doesn't have jurisdiction. And
why not? I'm going to play devil's advocate now.
No, that's fine.
Why not?
Well, a few reasons. One is that it clearly, as everyone agrees, the court does have jurisdiction to make a finding of abuse and neglect, and that is 100% reasonable in the sense that it's a finding as to a child.
So wait, because I got to tell you, it seems a bit insane that our justice system says to a child of sexual abuse, we're going to protect you until you're 18, and we can only continue to protect you if you go back to the very same dangerous place you were or place yourself in foster care. So if a child finds a way of getting away from her place of danger and it says, I need therapy, I'm messed up because of what my father did to me and what my mother let him do to me, right? The court is powerless to help this child?
I certainly agree that there can be concerns in this context, but in terms of the statute itself and the case law, it's clear that when the child then turns 18, she is considered no longer a child. And as the cases say, many cases, especially from the Second Department, there's a few, say no longer considered a neglected child. So
it's funny because when my daughter went off to college, the country said she was a child and that I, as a parent, was obligated to pay college, right? And even in the Family Court Act, it says that a parent must take care of a child until that child reaches 21. So I don't understand.
This is Judge Mazzarelli. Just explain to me, what's the point of having a hearing, a finding hearing, and making a finding and not being able to have a disposition? I don't understand that. I'm puzzled.
So there's a few issues here. First of all, in terms of Article 10, the Family Court Act defines child consistently as 18, with the that's the line. I know obviously in other contexts there's a different line. Here the Family Court Act does draw that distinction, with the exception, the important exception, of the child who, when they turn 18, consents to remain in foster care, which comes along with consenting to remain under the jurisdiction of the family court. And we see in other contexts as well that 18 is the dividing line in terms of custody, in terms of visitation. And so to answer your question, Justice Mazzarelli, I think part of the point is, first of all, there are often younger children who a finding may be relevant for, even if the older child, as in this case, is no longer under the jurisdiction of the family court, and so wouldn't be eligible to, well, the family court wouldn't be able to grant them or institute services. And there may be other future children. There may be many reasons why it's important to draw that line, but the line makes sense in the way that that's as to a child, whereas kind of reverse looking, if you want to put it that way, versus going forward, what will be the treatment or the organization going forward, whether there are various services in place and so forth. But I think it's clear that the statute itself draws this line with this exception, the specific exception it gives for foster care, in both in 1055 of the statute, where it specifically—
What do you say to Ms. Stern's argument that the court could have reached a conditional disposition granting services if the child consented to foster care placement? Could the court have done that, since the child is entitled to consent to the court's continued jurisdiction over her?
So there is a provision in 1055 and also in 1087 that a former foster child who has left foster care can petition to come back into foster care until the age of 21. And that's that's the system, I guess, if you want to put it that way, for even someone who's 18 continuing to be under the jurisdiction of the family court. The statute doesn't provide a provision for the child at that point the child can at that point be placed in foster care at 18. The statute clearly says no placement can be made without his or her consent. So in that sense, it can be made at that point. But the point is that it's clear that that's the only way in which the family court has the jurisdiction to engage to issue an order as to the now no longer a child, as the various cases put it, that the child is no longer considered a neglected child, just as in multiple cases, this court and other courts, the Appellate Division, have said that appeals by children who are over 18 are academic, and the appeal would be dismissed as to them, even if it continues as to younger children, again, based on the Family Court Act drawing this line at 18 here and in numerous places throughout. And the first sentence of the Family Court Act is, of course, that the purpose is to protect children, and it defines—
Well, that's certainly not being met here. Okay, so that line just doesn't seem to be apropos at this point. But I thank you, Mr. Zipkin.
Thank you.
Ms. Stern, you have 1 minute.
Thank you, Your Honor. I just want to respond to one of the arguments that Mr. Zipkin is making, and he's made in his brief, that the Article 10 only applies until age 18. And that clearly cannot be true. Certainly the petition, again, has to be filed before the age of 18. But if we were to follow that logic, then there could be no findings for child over 18. And the courts have found repeatedly, and there's no dispute, and respondent concedes that a finding can be made after the child's 18. If there can be a finding after a child is 18, it logically follows that there has to be a disposition. There has to be some determination of what services can be ordered to protect the child should the child request one.
Thank you. I think we've got it. Thank you so much.
Okay, thank you, Your Honor.
Thank you. Okay. Biggin versus City of New York. Ms. Duffy, you have 4 minutes.
Good afternoon, Your Honors. Caitlin Duffy from Brelling Associates on behalf of Plaintiff Appellant, and may it please the court. The trial court's decision granting defendant's motion for summary judgment disposing of plaintiff's disability discrimination claims brought under the broad remedial statute of the New York City Human Rights Law should be reversed. And the reason is simple. The trial court erred in making factual findings and credibility determinations that should have been left for the jury to decide. The jury is supposed to decide what happened here and who should be believed here, and instead the trial court made those determinations. Focusing on plaintiff's hostile work environment claim, this was based on the record that the trial court, that there were issues of material fact as to whether plaintiff was treated less well because of her mental disability. Specifically, there was an incident involving a defendant, Connor and Rapetti, two police officers at the precinct where plaintiff worked, where they essentially gave plaintiff a t-shirt.
We're familiar with the facts, counsel.
Certainly. So in dismissing this hostile work environment claim, the trial court essentially found that the actions here didn't rise to the level of anything more than a petty, slight or trivial inconvenience. And the court relied on its factual finding that there was no evidence of discriminatory intent. But the facts here, there were material issues of fact as to what defendant's intent was here. There were 4 facts that the court cited. One is that she requested the t-shirt, but the facts, plaintiff's testimony was that she was given the shirt by defendant Connor, that she did not request the shirt.
This wasn't an isolated incident though, right? As I understand from the record, she was given t-shirts often. This wasn't the first time she was given a t-shirt.
This was the first time she was given a t-shirt by defendant Connor, Your Honor. She had been given.
Counsel, am I correct that in her employment, other colleagues had given her t-shirts in the past?
That is correct, Your Honor. Other colleagues had given plaintiff t-shirts in the past. However, those t-shirts did not say "I'm dope" across them. Right. They were precinct affiliated t-shirts only, and related to fundraisers, essentially.
I understand the t-shirt was one associated with a rapper, right? And that the term "I'm dope," if you ask any young person, they will tell you that means that's cool. That's a good thing, not a bad thing.
That is one possible meaning, but it ignores the context here, which is
the context that her sister put into her head that they were calling her stupid.
No, her sister informed her what the t-shirt said. When Connor gave her the t-shirt, he told her it said "I'm fresh." When she took it home, her sister, because as you know, the plaintiff cannot read. When she took it home, her sister told her it says "I'm dope" on it, and plaintiff understood that to mean that they were saying "I'm stupid." She remembers that they were giggling when they took her picture with her in it. Under the city human rights law, you have to look at the totality of the circumstances here and the context. And the context here is plaintiff is a severely mentally disabled woman. Defendants gave her a shirt that said "I'm dope" in order to take a picture of her in it and laugh at her. That's the context. Defendants can argue to a jury that they meant it in the positive sense that she was dope, but ultimately that's a jury's determination. There's 2 versions here. One is, did the defendants...
Are you saying that one instance is enough to support a hostile environment, work environment claim?
It is, Your Honor. This court has found that single incidents can rise to the level of a hostile work environment when they essentially reveal to the disabled person in this case how her colleagues truly felt about her, which is that she is less than them. She was basically there as a joke. That's enough under the broad remedial statute of the New York City human rights law.
All right, you have some time on rebuttal.
Thank you.
Ms. Fillo, you have 4 minutes.
Thank you, Your Honor. Mackenzie Fillo for the respondents. There is simply no fact dispute here about the intent of the officers. The record shows that the plaintiff and the two officers had a friendly relationship for 20 years. They gave her t-shirts all the time. They bought her sodas and snacks. They helped her with the garbage. They attended events together like baseball games and retirement parties and clam bakes. They regularly took pictures together. On one occasion, they all dressed up as Con Ed workers with hard hats and took photos. Giving her the I'm Dope t-shirt is completely consistent with their friendship and in no way suggested that they were better than her or that they were ridiculing her. And that is especially clear because they gave the same t-shirt to two other police officers, neither one of whom was disabled. There is literally no evidence in the record that the police officers ever said or did anything mean to the plaintiff in 23 years for any reason alone at all.
Did they take pictures with the other two police officers to whom they gave the shirts or engage in any like behavior?
The record wasn't clear about whether they took, no one asked that question of any of the witnesses, but the general testimony was that the officers had lots of events at the precinct, that they included the plaintiff in all of these events, that she was an integral part of the fabric of the precinct. And they took photos at all of these events, and they regularly took photos of her, and that it wasn't in any way ridiculing her.
Counsel, did they know that she had this disability?
One of them testified that he knew that there was something off about her, and the other said he wasn't sure, that he thought he had seen her doing the crossword puzzle and the Sudoku, and so he wasn't sure. But either way, the evidence is clear that they never said or did anything mean to her because of her disability. And while my colleague claims they laughed at her, the plaintiff did testify that they laughed at her, and then she clarified that she did not actually see or hear them laugh at her, that in her mind they laughed at her, but that she did not see or hear them laugh at her. That is not evidence that they laughed at her. So if they didn't laugh at her, they gave her shirts all the time, they gave this same shirt to other people, they had a long friendship, there's just nothing here to this claim. The case is premised on a misunderstanding by the plaintiff's sister as to the meaning of I'm dope. When they gave her the shirt, she didn't understand what it meant. She asked, what does it mean? They said, it means I'm fresh or I'm cool. That's what she testified. It was only when she went home and her sister saw the shirt and didn't know what I'm dope meant. And again, as Your Honor mentioned, like put it into her head that they were making fun of her. There is no evidence that they were making fun of her. And so this claim was properly dismissed.
Thank you. Oh, go ahead.
Could I speak to the accommodation just for a minute?
Yes.
Thank you. The plaintiff received a reasonable accommodation for her knee injury. As soon as the NYPD found out that she had a knee problem, her supervisor immediately assigned another employee to do certain tasks for her, like carrying the mop bucket up the stairs. And the plaintiff testified that after that, she could perform all of her work duties. The obligations under the law were satisfied. The plaintiff also suggests that the supervisor was required to ask her about her intellectual disability and whether that required some sort of accommodation. But the plaintiff herself testified that she could do her job and that her disability did not interfere with it. And employers cannot go around asking people about their disabilities when there's no evidence that those disabilities are interfering with their ability to do their job. That would be discrimination. So the Supreme Court properly dismissed those claims as well.
Thank you.
Thank you.
Ms. Duffy, you have 1 minute.
Thank you, Your Honor. Just to circle back, the record is clear. Rapetti testified that he didn't take a picture. It's page 584 of the record. He didn't take a picture of any of the other individuals who allegedly received this T-shirt. Plaintiff testified that she never took any pictures with the defendants, and that's at record 219. And you know, my adversary is basically asking this court to do what the trial court did, which is make factual findings and make credibility determinations. The evidence that they're relying on is coming from the defendants only, and not taking into consideration what plaintiff's version of what happened is. And for that reason, because they have not established that there's a clear evidentiary route in which plaintiff cannot prevail at trial. The trial court's decision should be reversed. Thank you.
Thank you. People versus Saul Olavaria. Mr. Palmer.
Good afternoon.
Good afternoon.
Mr. Olavaria received an 11.5-year prison sentence for a robbery involving an unloaded pistol and no physical injuries. The 7-year minimum sentence adequately addresses the gravity of the offense and serves the purposes of punishment. Accordingly, this court should reduce Mr. Olavaria's sentence in the interest of justice. Although the alleged offenses were serious, the charges adequately captured the circumstances. As I said, there were no injuries that occurred as a result of the robbery.
Yes, but he scared to death a young child and his mother by sticking a gun in their face. Isn't that what happened here?
Of course, and
okay, so that kind of conduct belies a minimum sentence.
And we know that there was no intent to cause injury here, as the firearm was unloaded. And, you know, having a gun pointed at you, of course, is terrifying. But that does not aggravate.
And he followed up with not only pointing the gun, but also threatening to kill them if they didn't do what he wanted. So
right.
We have to add that.
And in light of all of these circumstances, the people still, prior to trial, deemed a 3.5 to 7-year sentence appropriate in offering Mr. Olavaria a plea to a nonviolent felony. And our argument is not that he received a trial tax here, just that the people's evaluation of their own case and its severity is relevant. A still lengthy 7-year sentence would be consistent with the purposes of punishment. Mr. Olavaria will be nearly 65 years old when his sentence expires in 2029, and he is not an offender who requires an incapacitatory sentence. Yes, Mr. Olavaria does have a substantial criminal record, but his most recent conviction prior to this case was from 1992, and he successfully completed parole after his 2006 release, serving 8 years on parole supervision. And after this arrest, in this case, Mr. Olavaria lived, worked, and complied with bail conditions in the community for 2 years without incident. He signed a bail bond twice a week, and the court noted that Mr. Olavaria had been nothing but punctual and respectful throughout the proceedings. A reduced sentence provides hope that he will be able to meaningfully participate in the workforce upon his release, and respondent asserts that rehabilitation is more likely to occur in a correctional facility. But reducing Mr. Olavaria's sentence will not undermine his rehabilitation efforts, as 7 years is plenty of time to complete programming such as the drug rehab services that the pre-sentence report recommended. And then finally, Mr. Olavaria must serve his sentence in a system that is frankly ill-equipped to meet his ever-increasing medical needs as he ages. We know that older inmates are physiologically older than their peers at liberty in the community and at a greater risk of both victimization and injury than their younger peers inside the correctional facilities. Our prisons simply are not built as nursing homes or assisted living retirement communities.
Thank you. He won't quite be ready for nursing home at 65, but you'll have a minute on rebuttal. Some of the justices of this court might take umbrage to that. Mr. White, you have 3 minutes.
Thank you, Your Honor. May it please the court, Matthew White for the people. The sentence was entirely appropriate for this gunpoint robbery of a family-owned and operated business, during which the defendant threatened a mother and her teenage son and pointed a gun at other employees and said, "I'll kill you if you don't back off." The sentence of 11.5 years was squarely between the sentencing range for the defendant.
Counsel, my question is, if the plea offer below was 3.5 to 7, right, and he chose to go to trial, is he being punished for having exercised his right to go to trial?
No, Your Honor. The plea offer of 3.5 years was premised, I think, it was offered before the suppression hearing, so it was essentially an incentive for the defendant to resolve this matter expeditiously without forcing the family to come in and to testify and relive that experience. They had to do that because the defendant refused the offer, and it was well within the court's discretion to impose that sentence, especially given the defendant's record, which includes prior felonies for attempted murder, first-degree robbery, grand larceny in the third degree, narcotics, and I believe bail jumping. So, the arguments about defendant's age don't really come into play. He was over 50 when he committed this offense. His family relationships appear to be of no moment to him because he was married when he committed this offense. And in terms of the medical conditions, none are really specified. It's mentioned in a footnote that he has bone spurs and osteoporosis and diabetes too. I don't want to minimize the seriousness of that, but it respectfully submit it's not a reason to reduce his sentence. And unless your honors have any questions, I ask that the sentence be affirmed. Thank you.
Thank you so much. Okay, trying to get the sunlight out of my face. I'm not being very successful here, but I will keep trying. Mr. Palmer, the floor is yours. You have a minute.
Just to clarify, Your Honor, I was not saying that everybody over a certain age is necessarily infirm or needs to be. Kidding you. Okay. All right. And I do understand what Mr. White is saying about, the purposes of plea bargaining and avoiding, trial and things like that. But of course, testifying and appearing in court is nerve-wracking and for everybody. I'm sure everybody here can, attest to that. But to increase the sentence 1.5 times just merely because someone went to trial, although the court did not abuse its discretion necessarily in giving that sentence, it doesn't really aggravate the circumstances in that way. And just to clarify, Mr. Olivaria's record is remote, and we do recognize that it is substantial, but the most recent offense occurred in 1992. And his age and family circumstances, yes, those were in place at the time of the offense, but he is still less likely to recidivate because of those facts than a person who was younger or was single and didn't have any family ties. And further, Mr. Olivaria has conditions and infirmities that plague many older people and are likely to be aggravated or at least more difficult to handle.
Were these conditions in place when he committed the offense?
My understanding is that he was diagnosed at a time after sentencing. And this court has recently considered outcomes for prisoners similarly situated to the defendant. For example, in a case Watt, which was not cited in our briefs, but there the court considered that people with certain mental handicaps are more likely to be victimized and placed in segregation than prisoners without those conditions. So it is something the court should consider. Thank you. So, thank you.
Thank you. Okay. Mr. Mironoff versus Memorial Hospital for Cancer and Allied Diseases. Appellant Mr. Schultz, you have 4 minutes.
Oh, thank you very much. My name is David Schultz. I'm an attorney with Barry McTiernan and Moore, and we represent Resource New Jersey, Inc. in this action. As I'm sure you've all noticed from the caption, there are numerous defendants in this action, and the claim, which arises out of the improper construction, design, or engineering of this staircase, plaintiff sued all the people that were involved with the construction. On the motion for summary judgment, Resource was able to prove that they did not have any work with the construction of the staircase Dr. Mironoff fell on. They didn't design it. They didn't perform any work on it. They didn't do any of the engineering with it. They pointed out in the affidavit the 2 staircases that they did perform work on and identified the staircase that Dr. Mironoff fell on, which was not one of the 2 staircases that they worked on. The staircase that Dr. Mironoff fell on was made of precast concrete that was not a substance that Resource worked with. The lower court denied the motion, saying that it was premature. But in doing so, where the lower court erred, is that in order for a motion to be premature, the opponents to the motion need to show that further discovery is likely to yield evidence that would be sufficient to oppose the current summary judgment motion. In this case, as I said, every single contractor involved with this project was named, and they all brought cross claims against Resource. And in opposition, nobody came forward with any evidence to say that Resource performed work on the staircase where Dr. Mironov fell, and nobody in support of their cross claim came forward with evidence or with even a statement saying that, hey, Resource performed work outside the scope of their contract, or on this day, Resource did this. On this day, now, nobody came forward with anything. They just said maybe the sworn affidavit shouldn't be believed, and that maybe it's customary at certain times that sometimes contractors perform work outside. None of that constitutes anything more than conjecture and speculation. And if I could do, maybe a little foresight, perhaps the lower court thought that in some of these cases, well, we'll deny the motion now, and then you'll just make the motion again at the end of discovery. In this case, that is a significant burden to put on a defendant that established their entitlement to summary judgment. There are going to be about 12 to 13 depositions of all the defendants. We have already started to do the deposition of Dr. Mironov, and we have already gone for 9 hours, and we are not done yet. So maybe sometimes the thought of, well, we'll just revisit this again, that's not really a fair burden to put on Resource. And unless the court has any questions, I'll rest on my brief.
Thank you. Okay. Mr. Simone?
Actually, Judge, I believe Mr. Serpico is going to.
Oh, Mr. Serpico. Okay.
Thank you.
Yes, thank you. May it please the court, Michael Serpico appearing on behalf of plaintiff respondent Mironov. As you know, plaintiff's burden was to demonstrate that the facts essential to oppose defendant's motion may lie within defendant's exclusive knowledge or control, and therefore cannot be stated by a plaintiff or co-defendants in opposition. Now, putting aside the obvious fact that no depositions were conducted prior to Resource's motion or appeal, which alone in many cases would be enough to properly deny the motion with leave to
Not
review.
where you have documentary evidence that seems to establish that there's no liability, then you have to come forward.
I agree. And in this case, there is additional support for a finding of prematurity. First, the only document exchanged by Resource prior to its motion was a contract with co-defendants. This contract had a scope of work that mentions work on stairs, treads, risers, but does not indicate which stairs. Second, along with its motion, Resource.
Counsel, but you are ignoring the submissions on the motion. So it gives you ironclad documentation of where he says their people were, what they worked on, and what materials they used. You now have to come forward and either controvert that evidence or put forward affidavits or documents of your own that put that into question. Where is that in the record?
That's what I was getting to. Attached to his affidavits were these color-coded floor plans with Resource's logo on them, order forms from Resource. All this document was not exchanged prior to the motion. At the very least, that establishes that there were documents that was in Resource's exclusive knowledge and control, and as well as the potentiality for more documents that generally found in construction projects, whether it's punch lists, work orders, daily reports, things like that. Defendants should be allowed to review all this discovery, which should have been served prior to defendant Resource's motion, as well as an opportunity to cross-examine the affiant.
Mr. Serpico, this is Judge Schulman. But the paper trail presented on this record, let's assume you're right, that you didn't get it in advance. But one thing is clear here on this record, that this company, Resource, only dealt with, and I'm waxing colloquial here, in what we would call rubberized type products. They didn't deal with precast cement. So how do you get over that hurdle? Why would another deposition of the affiants that put in affidavits here and supported a motion for summary judgment where they made clear what their company does, what it was doing here, that was clearly not involved in the actual staircase in question, which I looked up and saw the photograph of, where there's no rubberized treads. Those stairs are precast, which has indentation type treads in it. At least that's what I could discern with the glass panel, on the side. So the point is we know where she fell. We know the records show where Resource didn't work on it. And as Mr. Schultz pointed out, unless you have something that somehow puts Resource at this staircase based on this record, you haven't put in anything in opposition to create a material issue of fact.
Well, that's part of the problem. Their scope of work in their contract does not just say rubberized tile. It talks about risers and treads. It does not say specifically where on the property that work was to be done. It's not fair just to have plaintiff rely on the affidavit that's just going to come out with conclusory statements about what the work they did or didn't do. They didn't provide any.
3211 motions get granted in the state of New York every day. Where the documentary proof is there, you have to bring something forward. And other than contesting and saying that you haven't had a chance to depose someone, you have said absolutely nothing substantive about throwing any kind of, casting any doubt on the documents that were produced in this motion.
Well, that's the problem. I haven't gotten any discovery from defendant. I mean, they are in exclusive control of all of those documents. And the fact that they didn't exchange them prior to the motion establishes that even further.
Maybe I'm missing something here. This is Judge Mazzarelli, but I thought that the defendant, Ray, was to furnish and install floor coverings, carpet, vinyl, tile, resinous flooring, entrance matting, things of that nature. And it was my reading of the record here and the matters before us that none of those things were on the staircase on which the plaintiff fell. So you would have to be trying to show that the defendant, Ray, did work outside the scope of its contract in order to have some kind of association with this staircase. Am I right about that?
No, I believe the scope of the contract, the scope of the work in the contract lists risers and treads. And then even the affiant said
but that they were to put, I don't mean to interrupt you, but they were to put floor coverings on those risers and treads. Carpet, vinyl tile, resinous flooring, entrance matting. Is there anything in the record to lead us to the conclusion that such coverings were on the staircase where the plaintiff had the injury?
I believe what you're reading from is from the affidavit. What I'm referring to is the scope of the work in the contract that does say stair treads and risers, but does not say what stair tread and risers.
Okay, you'll have time on rebuttal. You have no rebuttal. Right. Sorry, your time is up. Mr. Simone.
Good afternoon, Your Honors. In my 23 years of arguing appeals, I've only been able to say the following one other time. I agree with everything plaintiff's counsel just said.
Well, that's dangerous.
So the notion of a summary judgment motion, I think let's get back to basics here, contemplates that there's been discovery. That's why it's generally done after a note of issue. The documentary evidence that Resource submitted was a self-serving affidavit, which I want to point out was not even in admissible form because it was an out-of-state affidavit. And generally, 3211, 3212 motions, an affidavit created just for that purpose of someone who has not been deposed is generally insufficient evidence for a motion.
Well, that's not the only evidence that was submitted.
Well, Your Honor, we're in the middle of discovery. There's a 3-page
I
discovery.
understand that, but that's not the only evidence that was submitted.
It
wasn't just his affidavit.
Well, the scope of work doesn't say, it says this is what we're supposed to do, including this. It doesn't say they didn't do what they're saying they did. You know, on a job site, and this job took place 8 years earlier. Discovery is going to take some time for everybody to get together here and to comply with this 3-page discovery order. They may be right that they didn't do any work, but on this record, they're not entitled to summary judgment yet. They need to at least give us the opportunity to depose them, because because you're submitting, a work order, page 399 of the record, that doesn't mean, it doesn't say that they didn't do work on the stairs. It's very vague what it says. We just want the opportunity to question them. That's all, and that's why it's perfectly fine for the judge to say, well, renewed after discovery. That's normal, and the judge could have said, you're not going to be able to do that because sometimes you just get one summary judgment motion. So I don't think it's far-reaching to say it's premature.
Well, Resource was a subcontractor, right?
Yeah.
And there was a GC as a part of this project, right?
Right.
And they oversee and coordinate the work typically.
Right.
So they have no records about who did what and where?
No, Judge, they probably did.
This subcontractor is the only party in this entire lawsuit that has any documentation about the construction project here and who did what and where they were on a given day, seeing as there are supposed to be ongoing documentation of work as it is occurring.
Judge, I'm not disagreeing with you that there's documentation, but this job.
So then where is there anything in this record, again, that contradicts in any way, that throws into question a memo, perhaps an email by somebody who said, hey, Resource, I know this isn't in your contract, but we need you to cover these stairs. Anything.
Judge, I can't speak to where this information is now because I'm not the trial counsel, I'm not defending the case, but they were in the midst of discovery. And I don't think it's fair to force an abbreviated discovery schedule on people because one party wants to writes an affidavit that's not even admissible, that just basically says what they wanted to say, and then submits a document that doesn't even support what they're saying.
Was there an objection to that affidavit in your opposition?
It was not mine. It was in plaintiff's.
And in reply, was that corrected?
I don't believe so.
Okay, thank you.
Thank you.
All right. Mr. Schultz, you have 1 minute. We can't hear you. You have to unmute.
What I was saying was, I don't think I have anything to add that we haven't already discussed, other than maybe to point out, as you did just moments ago, that in order for Mr. Simone's argument to make sense, it would be that Resource decided on their own, without telling anybody, without being directed, they just decided to go to a stairs in which they were not working on and gratuitously do work and not tell anybody. Every single defendant in this case has a cross-claim against Resource. If Resource actually had touched these stairs, one of these defendants would have said, as you pointed out, here's an email, here's a note, here's what I saw, here's our order to you.
You're the one who's moving for summary judgment. So it's your job to eliminate all issues of fact. It's not their job to eliminate them.
But true, and I would say that we did, in between the affidavit, the diagrams, and pointing out where we did do work, seeing as this case arises out of the construction, design, and engineering of this, and that we proved we did not do, and Resource did not do any of that, there was no evidence to show that further discovery is going to change that.
Can you address the issue of Mr. Simone with regard to the inadmissibility of the affidavit as an out-of-state person?
Only that was never an issue up until this moment.
Mr. Schultz, much was made by Mr. Serpico about the treads and risers in the scope of work, but then you submitted a bill of lading that actually described the actual materials used for treads and risers, i.e. something, pieces of treads and risers in the color of ammonite. That's a specific type of covering, and this staircase in question had none of that, correct?
That is correct. The stairs were precast concrete, and it was not anything Resource did or was doing.
So the bill of lading, in a sense, right up front, removed any issue about what the treads and risers were all about.
I would think so. I think there's more than just that, but yes.
I understand that. I understand. Okay, thank you.
Okay, thank you.
Thank you very much.
My apologies to the Council on American Transit Insurance Company. My colleague sent me a text to let me know that I skipped this appeal, so I'm going to call it now. Mr. Short, you have 4 minutes, and again, my apology to you on American Transit versus Health Plus Surgery Center. Mr. Short?
Yes, thank you very much. Skip Short and Billy for the appellant, American Transit. This case is brought under Insurance Law 5106 as an action to adjudicate a no-fault dispute de novo. 5106 requires that there be an arbitration award affirmed by a master of $5,000 or more. We have two such awards in this case: the award of the surgery center for $19,000, the award of the surgeon for $13,000.
Where does the statute say that you aggregate the awards in order to get to the 5,000? Because that's what you would have to do here.
Yes and no. I mean, we're already here for two of them because two are over 5,000. For the third one, at the time the statute was enacted, which was very early in no fault, there was no discussion of the possibility of the claim being split into three health providers. But I believe the Court of Appeals answered that question in Greenberg against Ryder Truck Rental, where there were two separate arbitration awards. The first one, which determined liability, was an award for no monetary amount. The second one was an award for a monetary amount. And the Court of Appeals in that case held that once the $5,000 threshold has been reached,
but that case wasn't similar to this. And in that Greenberg case, the issue was whether after the bifurcated arbitration, you were on the liability issue where there was no award made, whether or not you were entitled to a de novo adjudication. I don't see those facts as similar to this case, but maybe, you do.
Your Honor, at the time the legislature enacted or amended the law in 1977, and even now, there is nothing in all of insurance law, Article 51, that contemplates or talks about assignments or dividing the claim up into different parts. We have here one dispute for one surgery where...
Counsel, these are three separate providers. They bill separately. They are not interrelated, correct?
So far as I know,
the three separate providers are three separate entities.
That's true.
And they are entitled to submit their bill on their services.
That was not determined until the Court of Appeals decided Rosenblum against Geico in March of 1977, because the statute doesn't talk about assignments having any rights at all. And it was in that time period that the legislature amended Insurance Law 5106 to provide for de novo adjudication. So the legislature did not contemplate that the claim would be divided up. In the early days of no fault, it was customary that the injured party would file the entire claim. And it was not until 1977 that the Court of Appeals even established that an assignee could file a claim in the first place. Now, I also want to point out my adversary argues that if you permit American Transit to include the anesthesia in this claim, that the courts will be flooded with de novo adjudication. But this case presents a claim where in the same case, we already have the right to be in court because
yes, but you only have the right as to those claims where there was an arbitration award above 5,000, not below. You'll Correct. Have time on rebuttal. Mr. Kim, I'll hear you.
Yes, thank you, Your Honor. Good afternoon, Your Honors. May it please the court, Philip Kim for the respondent Citimed Services. As Your Honors already mentioned, the issue here ultimately boils down to whether different arbitration awards may be aggregated for the purposes of insurance law section 5106C. The statute is already clear that...
You're on mute, Judge Mazzarelli.
Sorry, I apologize. In this case, aren't all the awards relating to the same incident and the same injury?
Yes, Your Honor, that is correct. And it's also from the same surgery. However, it was by three separate medical entities, three separate bills were issued, three separate denials were issued, three separate arbitrations were filed, and three separate awards were made.
Well, does your opposing counsel is saying that we should lump them together because they're interrelated, and therefore reach the 5,000 threshold.
Yes, that is their argument. However, there's basically no basis in the statute or any of the trial court's decisions below that confirms their position.
Is there any case law, is there any case law that deals with this specific issue of having multiple providers on one incident submitting claims and going up before review?
I was unable to locate such a case where there were different amounts and some over the 5,000 limit. However, aggregating the awards should not be allowed in this case.
Okay, thank you. Mr. Short, you have 1 minute.
Thank you. I think, and I agree with counsel, this appears to be the first time that this exact situation has been presented to the court. And the one point I would like to emphasize is, in the words of the Court of Appeals in Greenberg against Ryder Truck Rental, once the $5,000 threshold has been met, in the words of the Court of Appeals, the entire dispute is subject to plenary adjudication. Now, while it's different because that was a wage claim and these are claims for medical bills, it is the same surgery. It's anesthesia for the surgery, which is already over the $5,000 threshold, and I believe that it would be appropriate to apply Greenberg here. Thank you very much.
Thank you. Wade Chung versus 48 Tenants Corp. And the St. Faustina Revocable Trust. Mr. Sobel, you have 6 minutes.
Good afternoon, Your Honors. If it please the court, Ms. Camo, I'll try and move quickly through some of the facts and circumstances surrounding this appeal. There is a decision that all parties, including the court, relied upon heavily, Campos. And the Campos decision talks to an issue of contractual indemnification and says that the surrounding facts and circumstances and the intent of the parties can be, if it can be clearly implied from the language of the entire agreement, that is what the court should be looking to. In that regard, we have a situation here where I represent a co-op corporation. The party who entered into the construction contract were the Gaffigans, a very popular comedian, and his wife, who had a very significant group of people helping them. They had a trust attorney, a real estate attorney, a business manager, an architect, a trustee, and they set up a trust to preserve their privacy when they bought this apartment, a full floor unit down on Great Jones. They then entered into an agreement with a contractor, a general contractor, who, by the way, is not a party to this litigation, but they entered into a contract with the GC. The agreement, that the contract that we're talking about, is the proprietary lease. That's the operative document here. And if any of you have ever lived in a co-op corporation, you know that the proprietary lease, the bylaws, house rules, that's what governs everybody's rights and remedies. Many of these and the provision really that speaks to the affirmative obligation and duty of the Gaffigans, Faustina Trust, sorry, is 3.4 of the amendment, which took place in 2009. By reference, the Gaffigans bought the unit in 2012.
Well, if I may, what in the record tells us that this is the 2009 amendment? Is that correct?
Yes, Your Honor.
That was actually affixed to the proprietary lease that was signed by the defendant. How do we know that they actually saw that?
Well, Your Honor, it's a point that was raised by my adversary and a point that was addressed by the court. The fact of the matter is that this document, this amendment, speaks to that. It says it was approved by the board. It was part of the agreement for several years before the trustee for the Gaffigans signed this document. And there's absolutely no evidence. And in fact, there is an alteration agreement. The terminology specific to that alteration agreement is only referenced in this amendment. So while the Gaffigans say that, or the trust says that the house rules they abided by, they provided insurance as required, they're pinpointing this one portion of the document. Now, there are multiple issues. There's house rules. There's other parts of the proprietary lease. Not each page was initialed, so we don't know that. But the only evidence we have in this case is from Ms. Fanning, who is the manager, and the dates upon which these documents were executed. And so that is what we've based our motion upon, that this was included. And it is not a reach, Your Honor, from the indemnification language that's found in the body of the original of the proprietary lease itself. The document that dates back to 1972, apparently. We know that because it was probably typed on a typewriter, but based upon the type. But in any event, the issue with that provision that was raised by my adversary was that the person who's injured here, Mr. Chung, who is an employee of a contractor retained by the trust for work inside the trust's apartment, the Gaffigan's apartment, there is no portion of this job that helped any portion of the common elements of the co-op. This is their private apartment. So it is absolutely typical that a tenant would get insurance. They did get insurance, and I would not be here if they had gotten proper insurance. But that's not the issue.
Typically in these type of co-op situations, a tenant could not even begin construction without board approval of that plan, and so that everything, the board presumably should know exactly what's going to happen, who has been hired, and typically they don't allow work to start until they receive the declaration page on the insurance. So who dropped the ball?
Well, unfortunately, the affirmative obligation here is on the trust. And from my understanding, they obtained insurance. They retained the general contractors who were supposedly obligated to insure both the co-op and the trust owners. But in this instance, there are affirmative obligations both in the proprietary lease and in the amendment, all which speak to what is normal in these circumstances, Judge Manzanet. You're absolutely right. When a co-op share owner renovates the interior of their apartment, they're supposed to get a general contractor. They're supposed to have proof of insurance. They're supposed to meet their contractual obligations because they're the only ones benefiting from the construction contract. This is not a situation like in the Agrispin case where there was work being done outside in the hallway or something that might mutually benefit. Here, there is an affirmative obligation. And the interesting thing about this kind of case is that my client, the co-op corporation, is only capable of being reached statutorily. They did nothing under common law. They did nothing. They don't have any common law negligence. They didn't run the job. They didn't oversee. They didn't supervise. They didn't do anything. The only way to get to my client is statutorily. So in 3.4 of the amendment, it specifically says that the tenant shareholder shall not permit work to be done that violates the statutes, which are the sole conduit to get to my client. They had an affirmative obligation to ensure that the work was not done. We're not seeking indemnification for our own negligence, which it runs throughout all of these types of cases. We're not seeking to expand that. We're simply seeking to have the tenant do what they do in other portions of the proprietary lease. For example, in the mechanics lien section of the proprietary lease.
Why don't you give me the example on rebuttal? Okay, we're out of your original time.
Not unusual.
Ms.
Thank you.
Okay, Ms. Camoy.
Yeah. Camo. Good afternoon. May it please the court. Lisa Camo for the defendant respondent, the trust, I'll call it. So I think the issues here are actually very simple. First issue is they want to rely for a summary judgment motion on an indemnification paragraph in a lease, which is a contract, and they didn't put in a copy of that in admissible form with proof that it was actually part of what they term the master agreement for the co-op. I don't know whether it was simply a housekeeping error and somehow that's what happened and it really should be in there. What we know from this record is that it's not signed, the page that the document that they want to rely on. There is a proprietary lease that Mrs. Gaffigan did identify from the 2012 time period, which says that all proprietary leases must be in this form, etc. Now, I'm not saying that that 100% proves that the earlier provisions could never have been included, but we have two indemnification clauses here. In the court below, they principally relied on the clause that's in the later 2012 proprietary lease, which is paragraph 9. And they also wanted to rely on what's really been discussed here today, which is 3.4 of the older proprietary lease. Now, the Campos case, we cite that case and cited it below for the proposition that the exact same indemnification language in paragraph 9, which we concede was in effect at the time, simply that this court interpreted that exact language and said that workmen are not visitors for purposes of an indemnity clause like that. So they've kind of abandoned that on this appeal now. Mr. Sobel's not really arguing that. What he's saying is, no, 3.4 was part of this. It's part of the master agreement. Everybody should know that it was. Unfortunately, we just don't. And I'm not trying to be cute in making this argument. It's just that it was their burden to come forward with proof in admissible form. They didn't do that. I think that's clear from the record. There's no evidence. Their own witness never identified this document, never identified the complete, whether it's house rules, master lease, etc. And we do address that in a lot of detail in our brief. But I think even more importantly, if you read paragraph 3.4, even if it applies, even if we want to say for the sake of argument, yes, it was in effect, it says that the indemnification is triggered if the tenant shareholder, i.e. the trust, the Gaffigans, if they are requiring, permitting, suffering, or allowing any work, etc., to take place in violation of various laws and regulations. And in this case, we're talking about the labor law. This is a plaintiff who fell off a ladder. It's labor law 240. There also were other motions and cross motions in the court below by the plaintiff and by the trust, which address, and they were denied as untimely, and they're not really the subject of this appeal. However, the trust made a showing extensively in connection with those aspects of the motions that the trust is not a responsible party under the labor law. As a matter of law, the trust couldn't have violated the labor law. Also, none of the industrial code regulations that the plaintiff was alleging under labor law 241.6 had any factual application here. And most importantly, I would submit to the court, I couldn't find a case that interpreted this exact language like we were able to do with the Campos case. But I would just submit to the court that in order for you to require, permit, suffer, or allow something to happen, you have to actually know about it. And the undisputed proof before the court is that nobody from the trust had any involvement, actual involvement, with the construction process. They contracted for it. They hired somebody to take care of it, the general contractor. The plaintiff was working there. He had no idea who they were. He had no idea who owned the apartment. The trust and the Gaffigans provided no equipment, no supervision. They weren't there. Mrs. Gaffigan was actually heavily pregnant at the time, most of the time that this construction was ongoing. They simply weren't there. So they could never have required, permitted, suffered, or allowed statutory violations to occur. I think that language is clear, and to the extent that it might be even remotely ambiguous, then it has to be construed against the tenants corp, against the owner. And from sort of an equitable point of view, Mr. Sobel was talking about the fact that they're only statutorily on the hook for a potential labor law 240 claim. But the Gaffigans aren't even statutorily on the hook because the law does not impose liability under the labor law on tenants like themselves as the owners of essentially a single family home, notwithstanding the fact that it's in a co-op building. So I would submit that the court, even if we want to say that this clause applies, the court can reach the issue of what that language means. I think it's plain, and that the court should actually affirmatively find, there's no point in kicking this back. The court should simply find that it can't apply here, given the undisputed facts and the testimony in the record about what the Gaffigans and the trust did or did not do.
Thank you.
Thank you very
Mr.
much.
Sobel, you have 2 minutes.
Very, very briefly, it seems that counsel wants to argue a motion that's not before this appellate division. Their motion for affirmative relief was untimely and was not considered by the lower court. And it can't be and should not be the focus of this court's purview at this point. The fact of the matter is that the Gaffigans had an affirmative obligation under the agreement that they signed that is inclusive of all parts of it that have been produced during discovery, never objected to, never parsed out until motion practice happened, that they have an affirmative obligation to keep labor law violations and industrial code violations from happening. So if what counsel says is true and they did nothing, they didn't supervise, they didn't oversee, they didn't do anything, that is tantamount to admitting that they failed to prevent and therefore permitted statutory violations to exist and or potentially exist, and therefore created the very conduit they didn't insure against to come through my client in an apartment and for renovation that was solely theirs. Taking the agreement as a whole, there are other provisions, all of which point in the same direction. The trust must indemnify and must remove all mechanics liens, for example, in one other portion. All of the provisions in the proprietary lease speak to the same right, the same obligation. And whether it's the initial one, where the court centered on the question of whether it's a worker is a visitor, and I admit, Campos says clearly that a worker is not a visitor. We're not talking about that. But you can't deny that it creates the obligation and reiterates the obligation in the 2009 amendment. And that was an amendment to a 1972 document.
These Counsel, you're out of time.
Thank you all very much.
Thank you. Eric Conrad versus City of New York. Appellant, you have 7 minutes.
Karen Dippold for the appellant. Gary Conrad was shot and killed by a team of 3 NYPD officers who were assigned to a strike that was taking place at 49th Street and 8th Avenue. Gary Conrad was actually in a grocery on the northeast corner of that intersection having a dispute with employees in the premises. Officer Kevin Gleason was asked to come into the store and deal with the dispute that was taking place. And the result of inviting him into the premises and having him handle this matter was that Gary Conrad ended up deceased, dead in the intersection of 49th Street and 8th Avenue, and a bystander was deprived of her professional abilities and was her health was permanently damaged.
Counsel, this is Judge Mendez. I just have a question. At the time that Officer Gleason goes down to the food emporium to address that dispute that's taking place between Mr. Conrad and the employees there, and he hears Mr. Conrad yelling and basically threatening some of those employees. Does he, at that point, have probable cause to arrest Mr. Conrad if he so chooses?
Actually, Officer Gleason says he was not intending to arrest. His initial statement, his statements about when he decided to arrest Mr. Conrad were varied greatly. His initial reaction was that he was going to talk to Mr. Conrad and he was going to investigate to find out what was going on. He wanted to know what was going on. So he did not initially assume that there was probable cause and that he was going to arrest Mr. Conrad.
Well, I don't know that the record says that. I agree with you that the officer wanted to try to deal with it in a different way and try to de-escalate. but I don't think there's anything in the record that says that he acknowledges or concedes that at that moment he didn't have a basis to arrest if he wanted to, which I believe was my colleague's question.
Well, he said that he was going to investigate the matter, and he was specifically asked, were you going to arrest Mr. Conrad? And he responded negatively initially. Yes. He said he was going to investigate, he was going to speak to Mr. Conrad. He followed Mr. Conrad up the escalator and outside the building. And at his Force Investigation Division interview, he says once he got outside the grocery, he started to talk to Mr. Conrad. It wasn't until then that he actually started to talk to him, although he subsequently changed his position about that and claimed that there was a conversation at the top of the escalator where Mr. Conrad threatened to kill him. And he said this was repeated once or twice and that he used the N-word despite the fact that that Officer Gleason was white.
So at that point, is there probable cause to arrest him? If Officer Gleason
the problem is that although he says that at his deposition, at the Force Investigation Division interview, he does not mention a conversation at the top of the escalator, and he does not mention that there were any threats made to him at that time at the top of the escalator. He added that allegation of these threats after he had viewed the surveillance videos approximately a week before his deposition. So that was a fact pattern that he added after seeing the surveillance videos and at his deposition. Then he adds the threats and the conversation at the top of the escalator. And if you look at one of the factors here is that if you look at the video surveillance, there's no conversation that appears to be taking place at the top of the escalator. You see Officer Gleason wave to Mr. Conrad to go into the revolving door, which he does very obediently, where Officer Gleason, for unexplained reasons, because the conversation that he says he relied on in attacking Mr. Conrad in the revolving door is not on the video, steps forward with his left foot and gives him a hard shove against the panel of the revolving door in front of him. And if you look at the outside surveillance tapes, you see Mr. Conrad pop out as if there was a force behind him. So the
Counsel, you have 1 more minute in your primary argument.
All right. Thank you, Your Honor. And I think the most important issue is that the court made this decision about the central question as to whether or not Police Officer Gleason identified Gary Conrad as an emotionally disturbed person in EDP. And he clearly did make that discretionary decision. And the facts in the case also that were never addressed by the court in its order.
Doesn't the eyewitness kind of contradict that conclusion that he was an EDP? The witness says that Mr. Conrad walks out of the revolving door, followed by the police officer. That she heard no confrontational speech between the officer and Mr. Conrad. That she saw nothing about his behavior alerted her to him being emotionally disturbed. Isn't that what she testified?
That is what she testified. She testified there was a calm conversation, and
so doesn't that undercut your argument that police officer Gleason should have concluded that he was emotionally disturbed? And while I recognize that some of his behavior may seem odd, in New York City, that's relative, right? What's odd can really vary in this city. So it seems to me that while the takedown seemed a bit over, utilizing more force than perhaps was necessary, is that the issue, or is the issue whether the officer at that point already had a sufficient legal basis to form an arrest?
The point you're talking about, where they're confronting each other on the sidewalk, is the point at which Officer Gleason says that he realized he was an EDP. He says when he saw the fists, the position that Mr. Conrad assumed, the threats, those are the things that made him think that Officer Gleason think he was an EDP. And I agree with you. This is why we need a finder of fact, that if you believe the bystander, if you believe Lauren Code's version of the facts, as opposed to Officer Gleason's version of the fact, there's a whole different situation unfolding in front of you. So I think that's one of the reasons why this case should be going to trial, because figuring out it's very clear that—
I got it. You'll have 2 minutes on rebuttal, okay?
All right.
Mr. Shapiro, you have 7 minutes.
May it please the court, Zach Shapiro for respondents. Plaintiff's argument about the patrol guide and the EDP standards is a red herring, because the patrol guide doesn't set the standard under the circumstances, as Your Honor's question suggests. Officer Gleason had probable cause to arrest based on the undisputed threats and racial slurs in the supermarket. And then the standard is, did he use objectively reasonable force under the circumstances in effectuating that arrest?
Well,
and that's
that
true.
video certainly doesn't bode well for that argument on your part. He is yanked down to the ground very forcefully. And quite frankly, I saw no reason for it based on what was on the video.
Well, Your Honor, the video shows that Conrad begins to run away and then forced to make a split-second decision about someone he believed posed an immediate threat of harm.
He was running away in the direction of other officers?
No, he was running away and he had just threatened to kill people, and Officer Gleason believed he posed an immediate threat of harm to other people. He didn't know to whom, because he kept threatening to kill people.
Well, he had been doing that all along and didn't arrest him at the outset. He had done that in the escalator, according to the officer, and he let him go through the revolving door.
Right. Under this court's opinion in Rodriguez, officers have discretion about when to effectuate an arrest, and the fact that maybe they, in retrospect, exercise poor judgment in not arresting someone sooner is not a basis for recognizing assault and battery or wrongful death claims. Forced to make a split-second decision as Conrad was running away, he reached out, grabbed onto the backpack, and then tried to pull him back to overcome his momentum. Now, maybe he didn't perfectly calibrate the amount of force needed to stop his momentum, but the objectively reasonable force standard is focused on trying to allow officers some leeway when they're in those kinds of tense situations with people who have shown that they present threats of harm.
At this point, this is Judge Shulman, at this point, there's no issue, at least on appeal, there's no issue with respect to having a basis for wrongful death. Am I correct?
Plaintiff is still asserting a wrongful death claim, but I think in addition to the point I was making, there's certainly no evidence of proximate causation here, because even if you think there might be some escalation that the person might fight back in some way, there's a huge leap from that to saying that that Conrad would pull out a knife that Gleason had no knowledge of, that he would then escape, and then once he escaped, he would charge at a separate officer with a knife, that he would continue charging even as that officer backpedaled and pointed a gun. So for that reason, in addition to the lawfulness of Mr. Gleason, of Officer Gleason's conduct, I don't think there is a basis for a wrongful death claim.
And the same could be said for assault and battery. There were no injuries.
They haven't presented any evidence of any injuries.
In fact, he bounced right up after the scuffle and was charging that other officer at the end of the video, where he was being repeatedly shot at. Correct?
That's exactly right, Your Honor. And to get to a point that Justice Manzanet was suggesting, plaintiff's argument really asked this court to make two logically contradictory inferences. One, that Officer Gleason identified—
Never assume what I'm suggesting from my question.
Of course, I don't mean to suggest that it—
my role here is to play devil's advocate back and forth in order to get the arguments out, but you continue.
Of course, I was seizing on the substance of your question. But the plaintiff's argument asked the court to make two logically contradictory inferences. One, that Officer Gleason identified Conrad as an EDP based on him threatening to kill him, and yet that he did not threaten to kill him. And that kind of Schrodinger's fact type claim, it's just not a basis to oppose summary judgment. Turning back to that, but I should add that in addition to the other points I've raised, the governmental function immunity doctrine further shielded Officer Gleason's conduct under the circumstances, as recognized in a series of cases, including this court's opinion in Kinsey. And on top of that, as I was saying, he did comply with the patrol guide, which recognizes that an officer can use force to restrain even an EDP who presents an immediate threat of harm. And
had he followed all of the rules of the patrol guide, we probably would not have been here. Okay, had he advised, had he gotten someone to go with him, had he advised his sergeant that there was something going on in the Emporium, there were a lot of opportunities here to slow this down. This didn't have to happen, but your points are well taken. Counsel, Mr. DePold, you have 2 minutes.
Yes, Your Honor, thank you. Your last statement is quite accurate. There were many opportunities. He didn't tell his supervisor, he didn't tell his partner that he was going in the store. They are confronted by this battle going on in the street. And as far as injuries go, the autopsy report and
just I want to stop you for a moment. When Judge Shulman asked about injuries, he's referring to those related to the battery charge, not with respect to the shooting. Obviously, he had severe injuries since it caused his death. We're talking about, was there any documentation of actual injuries that would have buttressed an assault charge on the initial taking him down, I believe is what my colleague was alluding to.
I understand what you're saying. And in fact, what the autopsy showed that there were many bruises and contusions to Mr. Conrad that would not be explained by shooting him. So there definitely was some kind of injury as a result of the forceful takedown. Also, it's with respect to the wrongful death claim, at the oral argument in this case, there was discussion about the fact that this is a but-for kind of situation. If Officer Gleason had told people what he was doing, if he had taken someone with him, the event that Officers Peralta and Sergeant Amundsen confronted would not have happened.
No, the but-for here is, I'm sorry, Judge Mazzarelli, I think you were about to say something. Go ahead.
Are you referring back now to the patrol guides? Because the protocols and the patrol guide, I thought that argument had been abandoned.
No, that argument isn't abandoned. As a matter of fact, the patrol guide is a measuring stick, and Officer Gleason didn't measure up. He didn't create a zone of safety. He actually made provocative remarks to Mr. Conrad, asking, "Are you really going to take me on?" He behaved in a way that showed that, like the Haddock case, he just didn't measure up under the patrol guide.
Under the circumstances we have here, it's not Officer Gleason who shot and killed Mr. Conrad. It's the other Officer Peralta, I believe, who was threatened by Mr. Conrad with a knife. And then he discharged a series of shots that killed Mr. Conrad. So
that is correct, Your Honor.
So I'm a little confused.
The shots were fired by the Sergeant Amundsen and by Officer Peralta.
But how is Officer Gleason's conduct? How does that? Isn't there attenuated intervening contact that takes the liability away from Officer Gleason for the death?
Well, because they had not been informed, the sergeant says, "I lost sight of him for a period of time." That's what he testifies. So when Peralta and Amundsen see this brawl going on in the sidewalk, they run over to help, and that's what and Officer Gleason's provocative statement is why Conrad decided to fight back. If Officer Gleason,
but what caused Conrad's death? The act that caused Conrad's death was his pulling out a knife and charging the officers. So that act is a superseding act, no?
It is a superseding act, but it's an act that only occurred because Officer Gleason provoked him, pursued him. He was right behind him. There was no.
Thank you so much. We've got your argument and we've got the briefs and the record. Thank you.
Thank you.
Otto versus Otto. Mr. Lynn Jr., you have 5 minutes.
Thank you, Your Honor. I want to start off by saying the central issue in this case and in every summary judgment case is does the burden of proof shift, and does the defendant have to come forward with admissible evidence, rather not the defendant, but the respondent on the motion have to come forward with admissible evidence. The court below in the record on appeal at page 15 in her decision made note of that and said that once there's a prima facie showing of entitlement to summary judgment, that the burden shifts. Here, defendant Otto moved for summary judgment based upon a number of documents that were all admissible in evidence. One was, of course, the collateral estoppel effect of the surrogate court's decision, Judge Anderson. Next was the accounting that was produced in the surrogate's court.
All of which did not consider the property here.
Your Honor, if I could refer you to page 250 of the record on appeal, and I think that's a root misconception of our opponent. They say that in their brief that Mr. Otto did not own any interest in this property, in the same sentence in which they mentioned that he didn't inherit under his father's will, nor did his brother and sister from the first marriage. But in any event, if you go to page 250, and if you want to go to page 249 or 248, you'll see spreadsheets done by the accounting that show the
Counsel, this court in a prior appeal, which I was on, said, we noted that the continuing fiduciary relationship between plaintiff and your client and the other limited partners we concluded that there was no basis for a stay of the action because any decision in the surrogate's court proceeding would not determine all of the questions raised in the action. And we were referring to the surrogate did not deal with this particular part of the estate. That's clear. So there's no collateral estoppel.
If you would look at the spreadsheets, they had to account for every penny that passed through, and they did so, and they showed it as to each capital account. And that calculation was done by the accountants in 2011, which was, I'm sorry, I think if my date is right. Yeah, 2011. And at that point in time, the objections to the accounting in surrogate's court were with respect to the first intermediate accountant. The second intermediate accounting didn't go to trial and get a decision from Judge Anderson, I believe, about 2 years ago. Any event, here we have, at this point, we've had depositions of all the parties.
Mr. Lynn, I'm sorry. Just picking up on what the JP was questioning you on. There is no dispute that your client owed Maria Otto approximately $800,000 from distributions from the sales of certain properties where she had an ownership interest ranging from either 10 or 15% or something, a certain percentage as a smaller. It is undisputed. So now she's saying, I want my money. Just bear with me. And then you counter that by saying, well, gee, based on the various operative agreements, we were entitled to indemnification for having to litigate and our costs. So we took the $800,000 and change, and we took care of ourselves. So in other words, she was the deep pocket here for that indemnification. That's the core issues here. So the question becomes, in searching this record, putting aside whether there was this kind of issue took place in the surrogate's court, it did not, and putting aside whether there was an overpayment of fees where your client agreed to pay back about $500,000 and change for settlement, and she refused to sign the settlement because of outstanding issues, and whether that refusal somehow prevented her from being able to get the distribution that she believes as a matter of contract right she was entitled to. So on this record, based on an admission that she was owed this money, then, and in a sense, that's unjudged enrichment. So where's the triable issue, Mr. Lynn? Where's the triable issue? And putting aside the right to indemnify, where on this record should she be the deep pocket, as opposed to having a pro rata piece of the action, so to speak, or pro rata responsibility that should have been borne among all the different parties here on the indemnification question. And that explains why Judge Maisley referred the matter to the referee to sort of flesh that all out. But putting that aside, where is the triable issue on what was owed to Ms. Maria Otto with respect to the $800,000 and change distribution?
Your Honor, if I could start at the beginning, you went through quite a bit there. The 500.
You have about 2 minutes.
I'm sorry.
I suggest that you answer this question as directly as you can.
I'm trying to. Thank you. The 500,000 was paid back. That's part of the 800, and so and that all has been balanced. And I don't have any argument with you on the 800,000 at all, sir. So. But the issue is on this case is one, the issue of indemnification. Two, whether on the motion for summary judgment, they had to come forward with admissible evidence. Mrs. Otto testified at her deposition when asked if she had an accountant who was going to prove how she was damaged. Her answer was that she had an accountant. It was the accountant that prepared her tax returns and that he was going to prove it. She never identified him as a witness. She never produced him as a witness. The motion for summary judgment was opposed by lawyers' affidavits with conclusions and Mrs. Otto's affidavit with conclusions and allegations, whereas the motion for summary judgment was supported by an accounting approved by the surrogates court insofar as it went, then an update of that accounting by the McGladrick polling firm, putting together and showing that everything was in balance, and that $500,000 had been paid and everything else had been paid, leaving only the issue of whether or not the 800 is suitable for indemnity to Mr. Otto. As to one of my issues,
on the basis of what? What contractual provision anywhere required her to indemnify all of the members when she was only a 10 to 16% holder?
Okay, Your Honor, if I may,
please answer my question. What document says she has to indemnify?
There's nothing in there that says that her indemnity has to be pro rata. The indemnity from all of the investors was
well, under what I just don't understand, other than a contract that requires her to indemnify, one is not presumed. So if we are then basing it on the relationship between these parties, and they were members, partners, as it were, in this real estate holdings, then it seems to me that if there is a liability that is left, that should be paid pro rata based on the shares of the partnership. That is typical. That is typically how we handle these matters, unless you have a contract that says otherwise. And I saw none asserted in your papers.
Well, first of all, Mr. Otto is not a party to any contract. What we have here is we have Mrs.
Counsel, all right. I know exactly what this case is about. You can respond in your time on rebuttal. Ms. B. Sunder.
Thank you, Your Honor. Good afternoon, Your Honors, and may it please the court. I'm going to focus in on the court's questions to appellant. So honing in on the indemnification argument, I agree with what the court has noted, that there is nothing in the agreement, and Mr. Lynn has not pointed to any, that says that Maria Otto herself is obligated to indemnify anyone, whether pro rata or not. It is the partnership that is obligated to indemnify, and that runs from the partnership to the general partners, not to Jonathan Otto, as Mr. Lynn also concedes, because Mr. Otto is not an individual party to that agreement. The frustrating part about this case is that there are a lot of different situations and different relationships, but at its core, when you hone in on it, not to conflate the arguments, Jonathan Otto, the Metro defendants, certainly not the Metro Trust, they are not parties to any of the limited partnership agreements at all. This is part of their argument that Judge Maisley should have dismissed the unjust enrichment claim. And as Judge Shulman correctly pointed out, there is no dispute, there is no triable issue of fact that Maria's money, Maria Otto's $815,000 and possibly more, was diverted from the real estate entities and taken to another entity that she had no relationship with, no contractual relationship, although this court has already found that there was, in fact, privity, proximity, a fiduciary relationship, and they parked it somewhere without her consent. The real estate entities, the limited partnership agreements, nothing authorized Jonathan Otto to make that determination. And at the end of the day, all of these entities were effectively, if not his alter ego, he certainly controlled them. And so the indemnification, you know, if at all, was not self-invoking. This wasn't for them to just decide that it was too cumbersome to maintain reserves, which Jonathan Otto himself conceded he had the obligation to do. And the very agreements that they are cloaking themselves with for the indemnification obligated him to maintain reserves before distributing the money out. And so he has nobody to blame but himself for not reserving that. I would also argue that the indemnification clauses do not apply at all. The indemnification clauses were only triggered if the general partners were acting pursuant to the authority of the agreement. They didn't do that. They were supposed to have distributed the money in accordance with Article 5 of almost every limited partnership agreement in there. They were supposed to have reserved money under Section 7.1A, I believe, of every limited partnership agreement. They didn't do that. What did they do? They decided to take her money and hold it hostage until they felt that they would just decide to spend it for her. That is not acting pursuant to the authority under the agreement. And so I would argue that the indemnification clause was not triggered, even if you go to any number of the other arguments here, which are the appellants never asserted it in an affirmative defense. They never asserted a cross-claim or a counterclaim. There is nothing to be severed here. And Judge Maisley's decision should be affirmed in all respects. I have one minor suggestion, which is that this indemnification issue should not have been referred out because the appellants did not meet their burden. It was procedurally defective. The word indemnification appears nowhere in their answer, and their answer is in the record. It's starting at 1595. So there's nothing to be tried on the indemnification issue, not because there's no issue of fact, but because there's nothing to be tried. And I will also add that, in fact, that when you dig even closer, because this requires multiple peeling of the onion with everything that has been thrown out by the appellants for over 10 years in which they've dangled Maria Otto's money in front of her to extract and to use it as leverage for something that they're not entitled to, a general release from her. When they've never, by the way, they've never fulfilled their obligation to account to her, which is also an obligation under the agreement and under the partnership law. However, the re judicata and collateral estoppel argument, it cuts both ways. And again, here the appellants are trying to wrap themselves in the surrogate's court proceeding, but distance themselves for the parts where it cuts against them. They have argued to this court and below that the Getry report, which found that the appellants were responsible for wrongdoing, and the 2006 settlement agreement is re judicata and collaterally stop certain issues in this case. And on that, I will agree with them that if you look closer at the 2006 settlement agreement, and it's in the record at 1114, that Jonathan Otto, the general partnership, released the limited partners from any indemnification. And on that page, it says that the limited partnership, the indemnifying party under those agreements, has no responsibility to the appellants for any more expenses than what is set forth in that provision, unless the entire partnership consents. And that didn't happen. So I don't like to use the phrase red herring, but this indemnification argument is all thrown in there to distract from the fact that Jonathan Otto and the entities that he controls played a shell game with Maria Otto's money. They say that the agreement precludes the unjust enrichment claim, but then they say that this agreement entitles them to self-invoke indemnification and spend her money as they see fit, without any determination, without that even coming to pass.
Thank you.
Thank you, Your Honors.
Okay. Mr. Lynn Jr., you have 1 minute.
Thank you, Your Honor. The accounting issues turned up by Getry Marcus were minor adjustments and were taken care of. As to what we're dealing with here, there was no cross motion for summary judgment. There was a request that would have been untimely had it been a cross motion for summary judgment to have the record searched. The court below found specifically on the open areas left by the appellate division from the last time this case was there, that there was no breach of fiduciary duty, but there were personal claims. The plaintiff is a shareholder or a partner in a limited liability company. The limited liability company owned real estate. Metro Capital was the managing agent for that real estate. And so since she had no privity direct with Metro, they weren't managing for her, they were managing for an entity that she was an investor in. There isn't a basis for her to pierce the corporate veil in her favor and then pierce it again by saying that John Otto, because he is an officer, therefore is liable to her for an accounting. We're piercing the corporate veil twice with no proof. There's no allegation in the complaint at all that Mr. Otto has any contractual relationship with her. Even the claim of unjust enrichment is between her and the entity that she invested in and Metro Capital. The indemnity agreements do go and indemnify any officers, directors, managers of any of the managing entities, such as Metro Capital. And so what we have here is it's not an allegation that Metro was not run in accordance with corporate governance, that there was commingling of its funds, that the corporate form was disregarded. No, there's a bare allegation that because Mr. Otto is the owner, that therefore he's the alter ego and justifies all these lawsuits against him. On that basis, every small businessman who owns a closely held corporation is not getting the benefit of the limited liability he thinks he gets when he incorporates. And so
hardly. Thank you. Thank you, sir. U.S. Life Insurance Company versus Horowitz.
Good afternoon, Your Honors. Kevin Schlosser for the appellants. May it please the court. As I see it, this case presents two principal issues of the strong public policy of the state of New York. One is respecting and recognizing the finality of arm's length settlements. And the other, of course, is the venerable public policy requiring that those who claim they've been duped by fraud take prudent and reasonable steps to protect themselves. So, in this critical time of our justice system, we're always looking for expedient and cost-efficient ways of resolving disputes. And the courts have recognized that settlement agreements and releases shouldn't be a starting point for further litigation. So when parties who are sophisticated and intelligent use all the bells and whistles, they have a formal written settlement agreement, they have a broad release, and they decide to release their claims, that should be respected. And the case law that we have analyzed through our briefs basically take the approach that you look at the settlement agreement, you look at the release, if on its face it releases the claim, the burden would shift to the other party who is seeking to circumvent that settlement agreement, claiming that, oh no, there must be some exclusion to the settlement. I didn't really release this claim. So here, the respondent on this claim, the insurance company, does in fact have the burden of showing that this release did not release the claim that they're seeking to bring here. And what they do is they use two arguments to try to circumvent the release. The first one, I think, deserves very short shrift, if anything, because they claim that this claim, in this case, does not concern, it's not in connection with the policy. And we show in the brief that that's directly contradicted by the allegations of the complaint itself throughout the entire complaint. The entire claim is about the policy. They claim that they were duped into settling and paying on the policy. So there's no question that the release is in connection with the policy. The next argument they make is that the release actually excludes this claim because they claim this, we didn't know about this, so it was excluded. So how do we analyze that? Well, as I said, the first place to look is the language of the release itself. And this release was one of those broad, all-encompassing, unqualified releases that use the language. First of all, it directly applies to the appellant attorneys by name. It says the party's attorneys. It also includes them by referring to them as anybody who acted in concert with the others. So we know they're covered by the release specifically. Then it describes the nature of the claim that's being released. I think you're on mute, Judge Mazzarelli.
Thank you. Thank you. I'm
happy to respond. I was talking too much. I'd like to answer some questions.
Good. So you'll straighten me out. You'll unconfuse me here.
Hopefully.
I'm a little confused. Now, you represent the United States Life Insurance Company.
No, I'm representing the attorney appellants who were released.
That's what it sounds like to me.
Yes, I'm glad. At least I got across.
That's what I thought, but
we have two appeals here.
I thought we had that's a cross appeal, is it not?
Exactly. We have two. We have two appeals.
Normally we go with the appeal first, so that's.
Well, just to explain the context of it, our side is appealing that aspect of the judge's decision that didn't dismiss the Judiciary 487 claim. based upon the release. We're saying that claim was released. The judge didn't analyze our argument and he left that claim in. So now we're saying he should
How
have.
about you let Judge Mazzarelli get her question out?
Yes.
Okay, so I understand that. I understand that the 487 claim is still extant and we have to consider what should happen to that claim. Now, yes. I'm puzzled, and I've been puzzled since I picked this case up. How you got any money out of United States Life Insurance Company, period?
Well, I mean, that's a good
I take
question.
exception to that, Your Honor.
Excuse me?
I mean,
I was joking, Your Honor. I said I take exception to that, Your Honor. It was a joke.
Well, I mean, they certainly, Your Honor, I agree with you. They certainly had enough here to suspect the claim and question it. They investigated it, and yet they paid the claim, and they settled it, and they gave a full release. So, you know, now to claim that after all this due diligence they did, and they thoroughly investigated it, that they've been duped into paying it is too little too late at this point. But in any event, I mean,
well, the release that I've seen really goes to Mr. Quick, which is a great name for someone involved in this particular transaction. And it really releases him.
No, there's a totally separate section of the release. It's on page 46. It's letter D there. It releases, this is why I said this release totally encompasses the attorneys that I represent, because it says—
Well, how can you release someone from an illegal act, if that's what it is? If that's what it is. How can you release lawyers from a violation of the rules of discipline, if that's what it is? How can you release people from that?
Okay, because it's a claim under a statute. This is a claim under the Judiciary Law, Section 487, and the release specifically says among the claims, and it says any and all manner of actions.
We understand that. The question is, under our state's jurisprudence, there are certain things that contracting parties cannot contract into. One of them is violating the law.
Right.
So you can't just say, you know, we don't like that statute and we agree not to abide by that statute.
I mean, if someone commits murder and the family of the person who's murdered says, oh, well, we're happy we got all this money for his life insurance, so the DA is not going to prosecute you for murder. You can't do that.
No, but this isn't like that at all. What you're suggesting, Your Honor, is that a claim for civil damages under Judiciary Law 47, which provides for a private right of action, can never be released. That's not the law.
Yes, I am suggesting that certain claims under 487 cannot be released because the attorney, if they're violated 487, is guilty of a misdemeanor.
That's a criminal prosecution.
I understand that.
But it's not. No. But there's different concepts here.
All right, you can tell us on rebuttal because you are way over your time. Mr. Lux?
Yes, thank you, Your Honors. Stephen Lux from Fishkin Lux on behalf of the respondent here, U.S. Life. Your Honor, we don't even need to get to the question of whether or not this claim could be released. And that's because this claim was not released. And it was not released for two reasons. First, Your Honors, it was not released because the claim, which is that the appellant lawyers bribed a critical fact witness in an underlying lawsuit with cash and a Rolex watch to give a false statement to induce U.S. Life into a settlement.
You had the witness's other statement.
That's absolutely correct. We had an interview
right.
with
you
this
had an
witness.
Actual interview with the live person.
That's right. That has nothing to do, though. So there's two issues here. The issue of reasonable reliance, I'm happy to, which is our cross appeal. I'm happy to talk about why it is that U.S. Life reasonably relied on the statement. But when we're talking about the
You
487
relied
claim,
on a statement when you had an interview, an actual physical interview to the contrary.
we had an
Where you could
interview.
ask the witness questions, you could probe the witness, and you
Sure.
relied on a piece of paper instead.
Oh, a video. It was a video. It took the form of a video, Your Honor. And we did that for several reasons. We did that because the speaker, Mr. Quick, was not adverse to U.S. Life. In fact, he had every incentive financially to say the exact opposite to what he said in this video. Because if Mr. Goldberg, the plaintiff in the underlying action, was not the beneficiary under the policy, then he, Mr. Quick, was. So we had every reason to believe what was in the video statement that Mr. Quick gave. And additionally, Your Honor, the fact that that statement was endorsed by officers of this court who were bound by ethical obligations not to fabricate false evidence gave it an additional indicia of reliability. But none of that really comes into play on the 487 claim. Why is that? That is because the 487 claim, this isn't about reliance. It's was there deceit in the underlying lawsuit? And I proffer to Your Honors that bribing a critical fact witness with cash on a Rolex watch is exactly what the private cause of action in 487 was designed to address. What the appeal is about, Your Honor, is counsel's arguing that the 487 claim was released. It was released. He's wrong for two reasons. He's wrong because the 487 claim does not relate to the underlying policy. It's a separate, complete, distinct tort that has no bearing on what the policy says in the underlying action or the rights that it confers. Yes, the 487 claim would not exist but for the policy, but there's too much attenuation here. We're talking about attorneys falsifying evidence in litigation. It does not matter what that litigation was about. What matters is they engaged in deceit that undermined the litigation process. Put another way, the 487 claim is about fraud in the litigation process without regard to the substance of what the underlying action is about. But more critical than that, Your Honors, the 487 claim was an unknown claim. It was an unknown claim at the time the settlement agreement was entered into. And it therefore, under the language of the parties' negotiated settlement agreement, was not released under Centro and its progeny. Why was that? Okay.
Thank you. Mr. Schlossler, you have 2 minutes.
Thank you. Again, a 487 claim is a civil claim, and there is no case law whatsoever that you cannot dismiss, or excuse me, you cannot release a claim of that nature.
I really can't even believe that you are arguing that attorneys can enter into an agreement to violate the judiciary law.
Okay, they're not.
To violate their ethics.
Okay, that's not, first of all, I have to make sure the record is clear that these attorneys have adamantly denied this allegation.
I would hope
so. I don't want the record to be, to indicate that this is some kind of concession on their part. They vehemently deny the charge that of bribery. But leaving that aside,
how about collusion?
Collusion. They deny everything. They deny that this witness was false. They deny that they bribed him. The money that they gave him was based upon the fact that the insurance company demanded a release from him. It was consideration. It wasn't a bribe.
Oh, so they're not denying that they gave him the Rolex. They're just denying what the reason for giving the Rolex is.
That's correct. That's correct. But that's significant. It's key. It's absolutely key. But besides that, this release specifically covers this claim. It says any and all manner of actions of any nature whatsoever, including at law. That's it. It's as broad as they come. There's no limitation. The insurance
Now the
company,
question is it enforceable? Or is it against public policy to try to contract away your ethical obligations?
No, because if
counsel, thank you. You have had your 2 minutes. Mr. Lux.
Thank you, Your Honor. Just going back to just because one point I didn't get to on the 487 claim is that this was an unknown claim. And the law is clear. The Court of Appeals tells us that a release, even a broad release, can only release an unknown claim at the time of the settlement agreement if it says so. And this one does not say that. So like the Centro case,
Have
our
you argued,
release here,
sir, have you argued that you cannot release criminal acts?
that's not part of the appeal, Your Honor. No. The Centro opinion very clearly tells us that just the mere reference to any and all manner of actions isn't enough to release unknown claims. And we allege that this was an unknown claim. So, and I'll move on to our cross appeal just in the time that we have remaining.
You have 1 minute.
The dismissal of the fraud-based claim at the pleading stage based on lack of reasonable reliance is only appropriate in the rarest of circumstances, none of which are present here. There's under Court of Appeals precedent, there's two things need to be satisfied in order for there to be a dismissal on a motion to dismiss based on reasonable reliance. The first is that the misrepresented facts were peculiarly within the knowledge of the defendants. I'm sorry, the plaintiffs rather. And that is just the opposite of what we have here. Here, we allege that the attorneys and Goldberg were involved in the scheme. Quick was part of it, and we knew nothing about it. They knew everything about it. So the first prong is not satisfied. The second prong is not satisfied because despite its efforts, U.S. Life did not learn and could not have learned the truth through the exercise of ordinary intelligence, not due diligence, intelligence. And I'll just cite the court really quickly in my remaining time.
Counsel, I would suggest if there's another factor, you go to it because you're out of time.
Under the ordinary intelligence factor, I refer the court to the DDJ Management LLC case, which tells us that whereas here a settlement agreement has a representation and a warranty, we actually don't even need to get to the question of whether or not the reliance was reasonable. Thank you, Your Honors, for your time.
You. Millicent Thomas versus Church of St. John Visitation Parish and Triborough Maintenance Corp. Oh, I'm sorry, that is a submission. Ashley McMickle versus the DOE. Mr. Carlin, you have 3 minutes.
Thank you. May it please the court, good evening.
Good evening.
My name is Stuart Carlin. I represent the appellant in this appeal. I have a little bit of good news here, which is I think we have an agreement that there's a compulsory arbitration, so there's an adequate evidence standard that applies to the review by this court as to whether or not the medical determination by the doctor below was arbitrary and capricious. This motion should be reviewed under the prism of a motion to dismiss standard, and it should be de novo. And if you look at the record below, to say that the cupboard is bare in this record would be a gross understatement. It is the agency's obligation really to have presented all the medical evidence in terms of the records which supports the doctor's conclusion. The only thing that's in the record right now before the court is an SS decision which supports my client completely, that her problems started after the accident and that she was completely disabled. There is the determination by the doctor, and then there's a one-page injury report filled out by my client at page 153. There's really no analysis from the doctor after March of 2004. There's no evidence in the record other than he said he meant that it was a conversation that he had about a prior accident years before, even though my client continued to work and there was no incidents until after the fall. So the case law, I think, is clear. There needs to be some credible evidence, and when there isn't, this case should be remanded back. I think that is appropriate in this case, that the agency should attach the medical record. And And that's about all I have to say on this appeal at this
Okay.
point, and I'll reserve the rest of my time.
Thank you.
Yeah.
Ms. Paulson.
Good afternoon, Your Honors. May it please the court, Susan Paulson on behalf of DOE. Your Honors, the appellant appears to be raising a new argument for the first time on appeal that the record is incomplete due to the absence of underlying medical records. This is not something that he raised in Supreme Court or argued that Supreme Court could not rule on the motion due to inadequate evidence. The medical evidence that's in the record is the summary of the evidence provided by the medical arbitrator, which honestly is not in dispute. What is in dispute is the conclusions that the medical arbitrator derived from that evidence. And the Social Security Administration disability determination is a complete, again, I apologize for using the term, red herring. The Social Security was making a disability determination, not a causation determination. And they determined that she was disabled after the accident, which was the question before them, did not determine whether it was because of the accident. To the contrary, neither the medical bureau nor the medical arbitrator made a determination of disability. They did not determine she was not disabled. They only determined that there was no causal link between her continued absence from work and the line of duty incident that occurred in January 2014. The decision was procedurally sound. It was in accordance with the procedures set forth in the collective bargaining agreement, which is in the record at page 124 and 125. And if you look in our brief on page 5, we cite to the UFT medical arbitration information, which tells the union members, when you appear, make sure you bring copies of all relevant medical documents that you believe will convince the medical arbitrator that the Department of Ed Medical Bureau made the wrong decision. She brought records to the medical arbitrator. The medical arbitrator correctly summarized them, recognizing degenerative changes in her shoulder and her lumbar spine and the cervical spine. There's no dispute that she had various underlying conditions here. From that information, the medical arbitrator determined that because the hospital said there was no finding of need for diagnostic tests when she arrived after the slip and fall, and that she could return to work, there appeared to be no incident on January 2014 that gave rise to some of these continuing conditions that she does, in fact, suffer from. She had reported being diagnosed with lumbar disc disease and cervical disc disease 4 years prior. And from this, the medical arbitrator, that would provide adequate evidence on the basis of which the medical arbitrator concluded that there was no, that her continued absence from work was not a result of that slip and fall in January 2014. As I said, he comported with the relevant procedural provisions in the collective bargaining agreement. There was adequate evidence in the record to support it. The Social Security Administration disability determination is of a completely different question that was before them. And I will just note that as to that determination, in addition, the records, her records showed degenerative changes in her lumbar and cervical spine and left shoulder. And that's what the Social Security Administration determined were the disabling conditions. Nonetheless, the Social Security Administration said on page 42 that she had residual functional capacity and could continue to work with limitations.
Thank you so much.
Thank you very much, Your Honors. I would ask that you affirm.
Thank you. Mr. Carlin, you have 1 minute.
Thank you. Just a quick response on page 10 of my memo of law, which I didn't make part of the record because you generally don't make it part of the record. It was argued that there was insufficient evidence to base that the record was inadequate, basically, period. And there's nothing before this court, really, other than this doctor's decision and a one-page letter entitled Comprehensive Injury Report, which is a handwritten note from my client. And that's all that is before this court. The agency should have submitted the entire record, so the judge would have been able to review what's in the record to see if his determination was arbitrary and capricious. I argued in my memo, which is filed in court on page 10, that there was insufficient evidence, and I obviously argued it in my appellate brief. And I think it's clear that the record is insufficient the way it is right now, and it should be remanded back. There's no question. My client.
Thank you so much.
Okay. Well, just one other point. I mean, because this is a causation issue. My client, as I understand my adversary, I don't think there's a dispute that she's disabled. It's really the causation. Was it the slip and fall, or was this supposedly something that happened several years before?
Right. We got it, Mr. Carlin. You're out of time. Thank you.
Thank you.
Add Plumbing Inc. versus the Burlington Insurance Company. Mr. Delahunt, you have 5 minutes.
Yes, thank you, Your Honor. May it please the court. This is truly one of those appeals wherein if the decision below is affirmed, it will effect a change in the law. And I don't mean just a change in the sense of an expansion of the law or distinguishing prior case law. It would in fact be a massive reversal of the law, because under the decision, an insurer need not issue a disclaimer under the statute unless and until its insured is sued. And there have been, over the decades, scores, if not hundreds, of reported decisions addressing Section 3420D and its predecessors. And the standard, the test, which is articulated in the body of that case law consistently, from the Court of Appeals down, is clear that the obligation to issue the disclaimer is triggered at the point where the insurance company has sufficient knowledge to do so. That is a standard that's not just consistent with the statute, it's mandated by the statute, because the statute speaks in terms of disclaimers for accidents, not lawsuits. Lawsuits are not mentioned in the statute. It's also consistent with how liability insurance works in New York generally, which is because insurers, policyholders, are not entitled to wait until they get sued to provide notice to their insurance company. And likewise, by statute, insurance companies are not entitled to wait unless and until their insured is sued to issue a disclaimer. I'd also submit respectfully that if the decision below were affirmed, it's also antithetical to the spirit of the law and the intent of the law as the case law has made clear, which is it would keep the insured as well as the injured parties in the dark about coverage. And as I note in my brief, it leaves the injured party in the situation of having to sue to determine if there is an insurance recovery for its claim. And it likewise requires the policyholder to wait until it's sued to know whether it has insurance for its potential liability. And we do not appeal the applicability of the exclusion here, but as I do point out in a footnote in the reply brief, this is an exclusion as worded, although it's been enforced, would not tend to give a policyholder explicit notice that it does not have coverage for these types of suits. And so this is just one anecdotal reason why the statute, such as it is, exists. And that's all I have for the panel, unless there are questions for me, and thank you.
Okay, thank you. Mr. Adrian, you have 5 minutes.
Good afternoon, Your Honors. May it please the court. It's actually Mr. Bergen arguing for Adrian and Associates. Your Honor, we do agree with counsel in one respect, at least, that is that a significant overhaul of 3420 appears to be at issue in this case. 3420, as plainly stated in the text itself, places a timeliness obligation on an insurer for two specific actions: when an insurer is disclaiming liability or denying coverage. And as the motion court correctly held, 3420 is therefore triggered, 3422D, in two circumstances: where there is a demand for coverage resulting in a denial of coverage, or where there is at least a lawsuit alleging a liability against an insured, resulting in a disclaimer of liability.
But typically, an insured not only has an obligation to inform an insurance company that an incident, that a claim is being made on the policy, they have an obligation ahead of that to notify the insurance company when an occurrence has happened that might create a claim. Isn't that right?
Your Honor, it is true that under most insurance policies, and separately under 3420, the insured also has certain notice obligations.
Right.
But that is not an issue in this case. The notification which ADD allegedly sent stated explicitly that it was for records only. There is no suggestion, nor could there possibly be, that it was anything.
Of course, but it in short order in September, which was just 2 months after the initial statement by plaintiff, in September, the agent for your insurance company received a copy of a summons and complaint against the owner of that building. So clearly 2 months after ADD notified you of an occurrence, you were now on notice that there was a complaint filed and a suit had commenced. So at that point, you certainly had enough information to make a determination whether your policy was implicated.
Your Honor, respectfully, the submission in September involved the high school. The complaint did not reference ADD at all, and in fact, as the record on appeal states, I believe it's at 263 and 283. Upon receiving it, Burlington began its inquiry. It reached out to ADD.
Really? Your agent said and acknowledged receipt of that September 5th communication and stated that it would contact ADD Plumbing in order to get the details. So there was a realization by the agent of the defendant here that there was a connection between the claim that was you were being notified about and your insured ADD.
And Your Honor, that communication is exactly what I was referring to. To be clear, the agent didn't know that there was a connection, but the fact that there may have been a connection was exactly why the agent, and it's in the record on appeal, reached out to ADD and asked ADD. It asked, has there been a tender made? Is this entity, is there a contract between you? Have you heard anything about this? Sent follow-ups, and you'll notice the record on appeal contains all those communications, Your Honor, and no response from ADD. There was no claim made against Burlington's policy.
Right, but then on September 17th, you received a claim from Granite with regard to the workers' compensation carrier for ADD, placing you on notice, claiming it had subrogation rights. So again, all along, there are multiple different communications, and indeed, your agent begins a investigation into it in September.
Your Honor, again, that we're talking about different issues here. There is an entirely different investigation and an entirely different analysis to be done by the insurance company, whether certainly for a subrogation right claim or indeed an additional insured potential claim, versus an issue where ADD, the named insured, is seeking coverage under the policy.
Of course, those are all different claims. I understand that readily, of course. But what I am saying is that all of those things put your client on notice that there was a potential claim that they needed to assess and do something about, since they already had one lawsuit. They had already received notice of one lawsuit.
And Your Honor, that's exactly what Burlington did. Burlington attempted to do that. It reached out to ADD, it asked questions, it asked for documents. A workers' compensation claim made against another insurer certainly doesn't trigger Burlington's 3420 issues. And in this case, Burlington's investigation and its request that ADD help it in its attempting to establish what was at issue here is not the same question as whether 3420 is triggered, which can only be done as appellant's cases all show. Your Honor, appellant has cited to 12 cases in support of its position that these kind of notifications and totality of circumstances are sufficient to trigger 3420. Every single one of those cases, although
Counsel, how about the letter that was mailed to Burlington in November? Actually, two letters, one on November 6th and then another one on November 24th, basically asking that Burlington pick up the defense on that complaint that was filed against ADD. Base Russia.
The owner.
Yeah. Indeed, John, just to be clear for the timing of those, Burlington received the first letter, which was actually addressed to ADD and which ADD never sent to Burlington. But nonetheless, Burlington received that on the 17th of November. That was a request that ADD put its insurance carrier on notice and contained a copy of the lawsuit. Burlington then 28 days later, just 28 days later, secured further correspondence, which actually from the high school explained the relationship between the parties, explained here was the contract, provided a copy of the complaint, and 8 days after that disclaimed coverage. Those correspondences over a period of the first one, 28 or 29 days, and the second one, 8 days later, over a Thanksgiving period, I might add, Your Honor, and received by the various parties on Christmas Eve. There is nothing in this record that suggests that was any sort of unreasonable delay under 3420. There is no bright line rule, and certainly there's nothing in the record, nor is any case law submitted by appellant that suggests.
So when you put it all together, the first time they notify you, listen, someone had an accident, then the September complaint, then the granted letter, then the 2 November letters. Don't you think that, way before you disclaimed, you had sufficient reason to suspect that there was a claim being made, that somehow your policy was going to be involved?
Yeah, Your Honor, and I think this was this seems to be a misapprehension that I think has come from appellant's papers. The sufficient information question is after 3420 has been triggered. It is after 3420 has been triggered that you evaluate in the terms of the timing of the disclaimer that then gets issued. That's when that question, the totality of circumstances, the sufficiency of information, and whereas what we're talking about is whether 3420 is triggered, and a suggestion, a possibility, a speculation, a maybe, a might be, a could be, do not trigger 3420. The only things that can do that, as set forth in every case submitted by the appellant, is a request for coverage, a demand for coverage, a notification of a lawsuit. The Ace Packing case, that's the First Department case that I believe Your Honor is referring to, and that is being sort of kind of referred to by the appellant in this case, which governs the sufficiency of the knowledge. That comes into play after 3420 has been triggered. That determines whether the time period that the insurer took after 3420 was triggered to disclaim was timely or not. But that is not the issue in this case. The issue here is when 3420 itself was triggered, and it cannot be triggered simply by a notification that states for records only. There is no question to be begged.
But you keep on ignoring that you received the complaint in September.
But not alleging any liability against any insured under the Burlington policy, Your Honor.
They were an additional insured of
Your
ADD.
Honor, that is. Your Honor, sorry, I didn't mean to interrupt you, but that is absolutely not the case. There is no assumption that an entity who at that point were not claiming additional insured status under the Burlington policy, they just advised ADD that they would like to be covered under ADD's coverage. That is a far, far cry and requires significant analysis on the part of Burlington, for one, never mind a court, to determine whether they're an additional insured. It is not the case that an additional insured is automatically one just because it asks another entity to be so.
Okay. Thank you.
And Your Honor, I would
Mr.
just.
Delahunt, you have 1 minute.
Yes, Your Honor. Burlington is drawing distinctions in the statute of its own creation. There's 40 years approximately of 3420D litigation, and not a single decision, including the Court of Appeals, who has visited this issue, I think 4 times. No pronouncement that an insurance company can wait until a lawsuit to issue its disclaimer. That Burlington hangs its hat entirely on that, and it can't cite a single case for that proposition. And Burlington attempted this at the Second Department in the Galindo and Ferreira case that I address at length in my reply brief. It's the same arguments, the same attempt. It was rejected by the Second Department for the same reasons why I submit it must be rejected by this court. With all due respect to the court below, it just did not apply the law correctly here on a set of otherwise undisputed material facts. Thank you.
Thank you so much. And last but not least, Breakaway Courier Corporation, Current Lighting and Electric versus Berkshire. I'm having trouble. Please help me. How do you pronounce your name?
Berkshire Hathaway.
May it please the court, my name is Raymond Dowd, and I represent Current Lighting and Alternative Fuels. May I proceed, Your Honor?
Yes, you may.
Thank you, Your Honor. The trial court's denial of discovery into BHI's, Berkshire Hathaway Inc.'s excess loss agreement with Continental General Indemnity, that's an integral part of the challenged reinsurance treaty, was reversible error. Now, we haven't had any discovery in this case. We've pointed out at page 205 of the record that an excess loss agreement exists by which BHI takes enormous amount of money out of this scheme, and we asked for discovery limited to that, to the payments back and forth between Berkshire Hathaway and CGI based on that excess loss agreement. So this is not a fishing expedition. And the action was dismissed with no jurisdictional discovery with prejudice.
Mr. Dowd, Judge Shulman, it is noted on this record that you did a lot of the heavy lifting in trying to put together and somehow link the pleadings in countering Mr. Jasek's affidavit. That is pretty much the keystone or key to breakaway, to BHI claiming that there's no jurisdiction in New York. Mr. Jasek, someone with personal knowledge, with a sufficient ability of authority with BHI, set forth various facts. Clearly, and I don't need to go through the affidavit, it's not very long, but I know you know it. We didn't do business as an insurance company in New York, and all the different points that he makes. And there's no doubt on this record that the various defendants that you sued, and I'm using the defined term, the applied defendants, all that whole group, were doing business in New York and did deal with your clients and get them to be involved in the reinsurance participation agreements, which you claim was a scheme and not a proper investment vehicle. There's no question what your claim is against the applied defendant. The question is, do you have a claim? Does New York have jurisdiction over BHI? What on this record? I know it's a very voluminous one. I know you pointed to the 2016 financial statements, and you pointed to certain premiums that have been explained as tax payments. We know this record. What did you say? What among your clients came back with personal knowledge showing that BHI did business with all the different points that Mr. Jasek raised in his affidavit?
Yes. Well, first of all, we don't accept Mr. Jasek's affidavit on any level as being either truthful or accurate, and it's absolutely contradicted by the record evidence that shows payments directly to BHI from ACRA. So that's specifically in the reference. But let's step back for a second and look at the big picture to answer Your Honor's question. First, Section 1509 of the insurance law specifically makes holding companies of insurance companies liable for acts that violate the insurance law by any of their subsidiaries. So we're not looking at a CPLR 302 long arm analysis. It's Section 1509 of the insurance law that provides the statute. Section 1213 also is a long arm statute that is much more expansive than 302 that governs insurance activities. Each of those statutes, we've argued in our brief, provide jurisdiction over the insurance law violations that we've alleged. And our two main points in the brief were not even responded to by my learned adversary. So there's no reference in Berkshire Hathaway's brief to either of our insurance law arguments. Also, the trial court below didn't even look at our insurance law arguments. This is an insurance case, and the judge didn't consider any of those jurisdictional arguments. 1213C is very clear on jurisdiction. Now, why is it that this deep pocket, Berkshire Hathaway, so important to keep in the case? California recently seized California Insurance Company. They found that assets had been taken out without authorization, that there were uncollateralized loans. We've alleged that this scheme is in danger of collapse. Why, before we've even had discovery, will we take the deep pocket out? At least this should be a without prejudice. At least let us have the discovery. So in this case.
Thank you. You reserved 1 minute. Do you want to argue now or hold on to your minute?
I'll take my minute. Thank you very much, Your Honor.
Okay. Mr. Karsich?
Thank you, Your Honor. Chris Karsich on behalf of Breakaway. I'll be rather brief because I agree with everything Mr. Dowd said. I think the important question here is, or as he pointed out, that the trial court did not look at the New York insurance law, and that's what provides the basic for jurisdiction here. The CPLR, I mean, the New York insurance law states that it is as broad as constitutionally permissible in terms of jurisdiction. So I think that's the basis on which Breakaway and the plaintiffs rely on, that there should be jurisdiction. And since Your Honor brought up the Jaksich affidavit, I think we've introduced evidence in the AIG parental guarantee that contradicts some of the major statements in that affidavit, raising questions of fact on a motion to dismiss that I think the court went beyond in determining. And some of those are that in that parental guarantee, it states that Berkshire Hathaway is doing reinsurance in the state of New York. It's agreed to New York State as the forum for disputes. So I think there's numerous questions of fact with regard to that, in addition to the statutes under the insurance law that would provide jurisdiction in this instance.
Thank you. Mr. Noser.
May it please the court, Michael Noser for Berkshire Hathaway. Perhaps one of the reasons the trial court did not deal with Section 1509 of the code is because it wasn't raised by the appellants at the trial court level. 1213 itself is not a jurisdictional statute. New York insurance law 1101 does talk about what constitutes the doing of business in New York for purposes of an insurance company, and the court might look at that and might look at all provisions of it, and not just the provisions that were cited by my learned adversaries. One of the provisions that they omitted was the one that says that guarantees are not a basis for jurisdiction over a party if it is done in a singular instance or rarely in conjunction with legitimate business transactions. Only if you're a professional guarantor company can you be considered to having done business in New York. And you'll note in the appellant's papers that they cite 1101 and they quote it fully, but they leave out that paragraph of all the paragraphs. That perhaps is why the trial court also might not have mentioned something like that, because it wasn't before the trial court and it was omitted from this particular provision here. I think that the court's questions are quite clear. Mr. Jaksich, the controller, certainly knows of what he speaks, and he swore to it. And he said that Berkshire Hathaway does not receive any premiums and never had received any premiums from any of these entities. They are a holding company that is licensed in Delaware and domiciled in Nebraska, and they do not operate an insurance business here in New York. There's no purpose in conducting discovery, voluminous discovery of Berkshire Hathaway on this record. They have not made the sufficient start necessary to justify such discovery. And I would submit respectfully, they've not come within a country mile of it. I'll rest.
Thank you so much. Mr. Dowd, you have 1 minute.
Yes, 3 quick points. First, the July 17, 2017 decision of Justice Friedman that talks about the pre-answer bond and Section 1213. is in the record, and that's the context under which all of this arose. The first sentence of section 1213 says the purpose of this section is to subject certain insurers to the jurisdiction of the courts. So it's clearly a jurisdictional statute. Last, Jack's affidavit talks about premiums. He's being cute. They're taking money out of this scheme. That's not a truthful affidavit, and we've made that point in our papers. So I'd like to rest and thank the court.
Thank you so much. This concludes the session of the Appellate Division, First Department. Good night.
Thank you.